Well, it was suspended as part of the evidence in chief.
Yes.
And so
he was sworn in and his witness statement was adopted or not. So we think after cross-examination we can put it in.
I'm sorry, after cross-examination?
Yes. Or maybe you think maybe they will cross-examine on that.
Exactly. So it would have been better if it's played before. My Lord, in fact, I mean, as... That's what I thought, my Lord.
To
somebody. I believe they are coming here because I needed to always have some background. So here's what I would say. Speed. Okay, to check. What do you remember that 1 hour before the declaration? What happened? Did they leave? They left. Do I remember former Ghana's ambassador to Zimbabwe?
Tamaklo? Yes,
Savannah came looking for
them.
Them. See, but specifically he was looking for Rujo.
Okay.
So he stood there and said, oh, they just went out. I think they will come because they are laptop and it's here. So he too was hanging around. Later, I was going to use the bathroom, but I saw him. I said, well, they will come, try and call him. So I just went to the bathroom and came back. He was still standing. When I came, they were not there. But we were waiting for Sabelugu and then certification of, I think, Bono East.
Okay.
Later, Bono East came, GUM side, MPP side, CPP side.
But NDC were not there.
NDC were not there.
So there's a story from the coalition room. There's a narrative that came out. Rojo Metal Nunu and
Mr.
Let me be reminded.
Hello? My lords, are we ready to proceed?
You just have to remind the witness of the former oath.
Okay. Mr. Robert Ojo Methodonu, on the 5th of February 2021, yes, you swore on the Bible to testify in this election petition to speak the truth, nothing but the truth. Do you still stand by it?
My lords, I stand by the oath I took as a witness, yes.
So you are reminded of that oath. My lords, witness is reminded of former oath.
Mr. Metununu, prior to you going into the strong room, did you familiarize yourself with the rules governing the 7th December elections?
My lords, yes, I did. I believe you are referring to CI 127.
Exactly so. Now, you know that under CI 127, the collation results that came to the EC headquarters that you describe as a strong room are only the presidential election results regional summary sheet from 12. Is that correct?
That is not the only information. That is not correct.
Now, if you look at the rules, what are you to receive from the regions? Tell the court.
In CI 127, the functions of the regional collation officer.
No, I'm not talking about I'm not talking about the regional collation officer. I'm talking about what you receive in the strong room. If you want to read, you need to seek permission from the court.
No, you asked me an initial question that do I know the procedure, the processes in the strong room? And I said that the regional results as submitted to the strong room should not just include the summary. It should include the 275 constituency results that make up that summary. Oh. You cannot present the summary without justification of the summary. So logically, the summary is justified in terms of verification by the representatives of the presidential candidates in the strong room by confirming that the additions of the summary are indeed true and accurate before you certify.
Now, let's move on. You granted an interview on the premises of the EC on the 8th of December 2020 to Kwesi Parker Wilson of Dry FM. Do you recall?
Yes, I do recall.
Now, in that interview, you stated that, among other things that you said that the NDC had deployed 275 lawyers throughout all the constituencies in Ghana. Do you recall?
I do recall. That is correct.
Did those representatives of yours, did they perform their roles diligently?
The legal representatives of the party, as deployed in the 275 constituencies and in the 16 regional collation centers of the EC, perform their duties, but they are not the returning officer of the EC. They are not the returning officer of the EC.
Now, if they did by the agents appointed by the petitioner at each constituency and for that matter, the regional level, is that correct?
If you are referring to the pink sheets that were officially handed over at the end of the collation, yes, that is correct. But in some other instances, many other pink sheets also started to appear.
Now, we'll go on.
You made a mistake on the Ashanti summary sheet declaration to give me a fair opportunity to answer the question. I'm a witness. I must be given a fair opportunity to answer the question.
I am saying that the next question I have for you is that would you tell this to the Ashanti region? Victor Kojogan Adaudu came out to speak against what you were doing because they, the legal team, after certifying everything, told Bojadin it was okay to sign Ashanti. I'm putting that to you.
I am not aware that the lawyer said anything contrary to what I was doing in the strong room. I have no knowledge of that,
well,
my lord.
It to you. It was all over in the social media and on the media as well.
No, you're asking me to testify, and I'm saying categorically that I have no knowledge of it. Social media was not available to me in the strong room. I'm sorry.
You also stated that, you know, in order for me,
I specifically indicated that I was cooperating fully with the Electoral Commission as a representative of the presidential candidate I was representing. I had a mandate to be there to seek his interest, and I was cooperating with the EC in that regard. There are previous instances of how the EC conducts the business of the strong room, and that includes the opportunity for representatives of the results from the regional level.
My lords, we respectfully ask for leave for him to
my lords,
by reference to those documents.
My lords, those 16 regional summary sheets are not part of any of the exhibits in this case. He cannot refer to them. He participated. My lord, I'm saying that as a matter of law. A party cannot refer to a document that is not in evidence to answer a question. It is not the right way to go.
A witness is in the box, especially in matters which we have to resort to documentary evidence. There may be a mass of evidence, and the witness may not have ready knowledge of everything. If he had something to do with it, it is allowable.
It is true that the witness cannot be expected.
But he's not a witness from nowhere. He is on oath as having said that.
My lord,
he took part as agent for the petitioner in the strong room. He probably had access to these.
Oh,
the proceedings or what happened at the strong room.
Yes. My Lord, now, the issue that we have at hand is that the petitioner refused to put any evidence before the court. Now, the witness, with the greatest respect, the witness there says that he has the summary sheets. With the greatest respect, I would want him to tell us. He should tell us, my Lord.
In other words,
yes, my Lord.
In other words, you have no objection to him referring to what he claims to be his summary sheet.
Yes, my Lord.
Yes. So let's go on.
He should go ahead. Tell us. Tell us the summary sheets that you signed and those that you didn't sign.
Right. My Lord, respectfully, counsel for the first respondent says he has no objection, but I believe counsel for the second respondent raised an objection, and I believe your lordships may want to consider that, and your lordships may wish to hear me. Your lordships may wish to hear me on that. Your lordships will notice that before I even asked your lordship's leave, I asked him what documents he's referring to. And he said the 16 summary sheets. And I asked him where he got it from. And he said he got it from the EC. So, my Lord, it is clear that those are documents that he is swearing on oath are official documents. The fact that they are not in evidence has nothing to do with a witness refreshing his memory by reference to those documents.
Yes.
So answer the question.
My lords, very well. The answer to the question are in two parts. They are in two parts. There are some documents that I signed or certified, and they are Upper West Region. Upper West Region. Then I certified.
Let's go on. You are going region by agent. Upper West Region. Your agent had signed on that form, not so. The regional agent had signed on that form 12, not so.
The Upper West Region, yes, the NDC agent in the person of Mohammed Ilyasu signed, and the summary sheet was officially signed at 3:26 p.m. on the 8th of December.
Yeah, Mr. Amanibo, I was reminding you, see, the question you asked a specific question to give you the summary sheets which he signed as a result of a mistake, and those he signed because he didn't want to, maybe create or place impediments. Now, he is doing so. Then after mentioning one, you stop him and then ask another question. You see, when you do that, you confuse the witness. Let the witness answer the question to the end. Then after that, maybe you can take them region by region, please.
Well, my lords. Please go.
My lords, may I continue?
Yes.
My lords, I also observed that the fax that was sent to the EC strong room
No.
Please.
was also received.
Mr. Meltinunu.
Yes, sir.
You are to tell
Your
the
Lordship.
court the forms that you certified by mistake and those that were in the witness statement where he said, I signed some because I didn't want to put spokes.
Mr. Chikata, that was the question that was on the table, and that's what we are waiting for the answer. I beg your pardon, hold on, may I finish, Mr. Chikata? Paragraph 21 of his witness statements. He says, I must also say that the fact that I signed sheets in respect of a number of regions shows clearly that my colleague and I were to put spokes in the wheel of the process of getting the proper basis for constitutionally appropriate declaration of the results of the presidential election to be made. And this is the paragraph that was read out to him. And so this is the answer, this is the question that my ears are open to hear the answer to. Could you kindly let the witness give us an answer?
Well, but if he's repeating the question by misleading the witness in terms of what is in that paragraph, because he says, tell us which he signed because he didn't want to put spokes in the wheel. The witness never said that.
That is the question he asked him.
He can say so. The witness can say so.
Please, proceed.
My lords, so in respect of Upper West region, the fax was also received.
No, you have spoken about Upper West. Can you go to the next region? Go to the next
I'm giving you the basis on which I signed some and the basis on which I did not sign some.
I did not ask.
That was the question.
You have given the court two reasons. One, you signed by mistake. Two, you did not want to put spokes in the works. You are telling the court, one, the one that you signed by momentous mistake. The second, the one that you signed because you didn't want to put spokes in the works. You have dealt with Upper West. Can we go to the next?
And I'm responding, my lords, I'm answering the question because there are some that have specific issues. I indicated in my statement that I had problems with the system of the EC. The system was not working. You have a situation where
Mr. Meto,
yes, my lord. Yes, my lord.
To help us to arrive at a decision that is premised on proper records. You have been asked the question. There are 16 regions. Please group the two answers into regions, and then you can move on, please.
Very well, my lord. Very well, my lord. So the Upper West region, I signed on the face of the summary without any confirmation of the constituency results that make up that summary. But I signed that one. That's Upper West region.
Go to the next region.
Northern region. Northern region, I had problems with that one. I had problems with Northern region.
So you didn't certify that one? You didn't certify Northern region?
I was taking up issue with the EC.
You did not certify Northern region. Please answer the question. You did not certify Northern region. Is that correct?
No, I did not certify Northern region.
So let's go to the next.
Very well. Ahafo.
Yes, we are waiting for you.
I certified Ahafo without having full access to the relevant constituency summary sheets that led to this summary, but I signed it.
What other region? You have mentioned three.
Central region.
Yes.
I signed Central region, but I had serious observations on the summary sheets in the way it was signed. Because if I'm permitted to show it in evidence, it will become very clear.
Let's go on to the next region. Let's go on to the next region.
Very well. Volta region.
Yes.
Volta. I certified Volta region.
Good. Let's go
again without the full complement of confirmation of the various constituency results.
Fine. Let's go on to the next.
Western North region. I signed Western North region, but we had issues with SEFI. Setri also.
Yes. Okay. Let's go on to the next.
I did not certify Greater Accra region.
Good. Let's go on to the next.
Because there were issues with the Greater Accra region summary sheets and how they came into the strong room.
Let's go on to the next.
Eastern region. Eastern region. In the case of Eastern region, we received 2 different summary sheets in the strong room.
Did you certify Eastern or you did not?
I did, but I was raising subsequent issues with the commissioner, and this was one of the regions with which I had issue. Eastern region, there were two results sent to the EC strong room. 2 results.
Your evidence in chief.
The law provides for only one summary sheet.
Listen to me. You have said so in your evidence in chief. Your 2 previous colleagues have spoken about it. Your answer to the question is that you certified Eastern. Is that not so?
Can you repeat the question, please?
Go to the next region.
Pardon?
Go to the next region.
Does it mean you're not asking the question on the...
with my answer. Go to the next region.
Very well. Bono East.
Yes.
We had issues with Bono East.
Did you certify or not?
Bono East was one of the summary sheets I did not sign. I'm answering the question. Can you be patient with me?
Okay, so
I did not sign Bono East. I did not sign Bono East.
Let's go on to the next region.
OT region. I did not. I observed some issues with OT.
Or you did not? OT.
But I certified, but I observed some challenges with OT, but I signed.
Let's go on to the next. Let's go on to the next.
Western region.
Yes.
I certified, but I drew attention to the EC to some anomalies which they corrected.
Let's go on to the next.
I signed.
Yes, good. Let's go on to the next.
I believe I've done Central region already.
You have. Let me assist you what is left. We have Northeast, Bono, Upper East.
Okay. Northeast. Northeast. I signed, but we had issues with the summation.
No problem. Now, Bono. Bono.
I signed Bono, but we had issues. I signed Bono, but we had issues.
Fantastic. Let's go.
German
Upper East. Upper East.
Upper East.
Savannah.
I signed Upper East region.
Great. Now let's go to Savannah.
Without the full complement of the confirmation from the constituencies.
Yes, so that is no worries. Let's go to Savannah.
Come again.
Let's go to Savannah.
Savannah.
Order in court, please. Order.
My lords, I cannot immediately find Savannah.
You cannot immediately? You are not talking about the now, we are talking about the then. Did you sign Savannah?
My lords, I wish to remind you that I said I needed to refresh my memory by looking at the very document before me. And if I cannot find Savannah, you're asking me to recall? I've just told you that I needed to refresh my memory by looking at the fiscal documents.
Have you found Savannah amongst your documents?
I believe I told your lordship that I was looking for Savannah.
All right, look for it. I'll wait for you.
Very well.
Are you waiting for me or I'm waiting for you? Look, let me put it to you so we move on. I am putting it to you that you certified Savannah and your agent called Mumuni S. Ibni signed on that form in the region before it came to Accra. I'm putting that to you. I need an answer so I can move on.
My lords, I have some issue with the microphone here. Can you please repeat the question?
I am saying that I am putting it to you that you certified Savannah and your agent in the region called Mumuni S. Ibni signed at the region before it came to the national.
That is correct.
Good. Now, the forms that you have before you, you know, on the right side, where they sign, there's a column that if you would not sign, you need to give reasons for your refusal or your failure to sign. Do you see that column?
Yes, I see the column.
Good. Now, I am putting it to you that all the forms that your regional agents did not sign, they didn't assign a single reason for their refusal to sign. I'm putting that to you.
My lord, could you repeat the question? Could you repeat the question?
I am saying that of all the forms that your agents in the regions did not sign, apart from Western North that you certified, they didn't assign any reason on the right column for their refusal to sign those forms. I'm putting that to you.
On the face of the summary sheets, that is the situation, but that doesn't mean that they didn't have issues.
No, no problem. Now, I am also putting it to you that if you look at the rules, the first respondent, together with you, the agents, were supposed to assemble and collate the presidential election results from the regions provided by the various regional collation officers as set out in Form 12 of the schedule. I'm putting that to you.
That is the rule, but not the practice. We are in court to review the performance relating to the practice and the efficiency with which they declare the results. That's why we're in court.
Mr. Witness,
we are specifically
the court will determine the reliefs.
We can't have the lawyers speaking. This is
right, go on.
I'm saying that yes, there is a provision for reasons if you refuse to sign. There are reasons if you refuse to sign. But I'm saying that even the EC's own officials certified various summary sheets in error. The blame is not only on party representatives and agents. The official representatives of the returning officer also certify results. They were not just there to just fill forms and forward it. They were there to make sure that the result of what was being forwarded was accurate and was not giving the opportunity for votes that had been cast to be lost in the declaration.
So speak for yourself. You are by this telling the court that your agents, including you, failed the petitioner monumentally by signing forms when they shouldn't sign, failing to assign reasons when they should. I am putting that to you.
That is incorrect. That is incorrect. Because on many occasions in the strong room even, the EC itself and its officials found the need to amend summary sheets of the regions. These had already been signed by the regional representatives, but they found it necessary to cause the various results to be re-amended without the presence of our agents. Without the presence of our agents. And it's for that reason that the returning officer, who is Jean Mensah, was expected to give an opportunity for redress before the final declaration. And that is why we went to seek audience with her. So, apart from the 4 regional summary sheets that I did not sign, apart from the 4 regional sheets that I did not sign, we later on discovered, for example, that there were other regions that had issues. And if they had been minded to have that amended, we would not be in this situation we are in now.
Right.
Dr. Afarijan gave opportunity in the past for some of these things to be rectified. He did. He gave opportunity for these things to be rectified.
Mr. Metununu, you recall that you indicated to the court that you have familiarized yourself with the rules under CI 127, not so?
That is correct.
Are you well aware that CI 127 revoked the arrangements that used to be the practice under Afarijan, as you have said? Are you aware?
It did not entirely revoke that. It said that in the new amendment and in the new arrangement, you must still maintain best practices. They didn't throw out everything in the previous thing. They said you must have best practices. Best practices.
Good. When did you leave the strong room for the second time on the 9th?
I left the strong room. The first time I left the strong room was when the EC sacked me from the strong room. That was the first time I left the room.
When was
the
this?
EC sacked me from the strong room.
When was this?
It had never happened before.
When was
In
this?
previous elections, I stayed there for 72 hours.
When was this?
That I left the strong room for the second time.
For the second time, that's what I'm asking you.
I left the strong room the second time to seek audience with the Electoral Commissioner. That was when, come again?
The time of the day.
It was somewhere between 3 o'clock and 4 o'clock.
On what day?
But you have already said it's on the 9th. It's on the 9th.
Well, if you are being rude, it's to the court, not to me.
No, you made the question. You said that on the 9th, when was the second time you left the room? And I'm answering. Then you are trying to, divert me to make some other statement. You are talking about the 9th, and I'm responding to you on the 9th that I left the room for the second time between 3 and 4.
At the time you were leaving, had you seen the forms for the northern region? The original.
By the time I was leaving, yes, I had seen the forms for the northern region, and I had issues with the forms for the northern region.
Yes.
And that was one of the reasons I went to see the commissioner.
You had earlier told the court that you didn't sign that form. That is fine, but I just want to find out from you whether at the time you were leaving, you had seen the form from the northern region. Now, I believe that you answered that you had seen the form.
I can also tell you exactly the time I saw the forms.
Okay, that will be fine. Tell us.
Northern region, the northern region forms were faxed to the strong room at 3:47 p.m. Sorry, yeah, p.m. 3:47 p.m.
On what day?
On the 9th. On the 9th. On the 9th.
Thank you very much. So, at the time that you were leaving the strong room, all the original sheets had come. I am putting that to you. All had come. The northern was the last to come. I'm putting that to you.
As correct summary sheets.
As the summary sheets. You had seen all of them.
There's a distinction that has to be made.
Please answer my question. Leave the distinction for the.
Then that is not correct, because Greater Accra was outstanding. Eastern region was outstanding, to the best of my knowledge.
Now,
Bono was out. No, just a minute. In terms of correct summary sheets, you can fax something to the strong room, but it may not be correct. And the issue raised here is
Metal. Please listen, Metal Nunu, sorry. Please, this is a very simple question. Go straight to the point. He's not asking you genuine or whatever, or correct or incorrect or whatever. He's asking you a very simple question. Let's try and make some headway.
I repeat, that at the time that you were leaving after 3:47 p.m., when the northern sheet had come, all the 16 regional summary sheets had come, and you had seen them.
All the 16?
Yes.
All the 16?
Yes.
That is correct.
Thank you.
Even though we had issues
Thank you.
with some of the summary sheets.
Now the petitioner has always had a problem with the chairperson of the EC, not so?
I do not exactly know what you mean by that.
When the chairperson of the EC was appointed, the petitioner and your party raised issues with that appointment. Is that not so?
My who and my who? I didn't hear the question.
I said the petitioner and your party, the NDC party.
I heard anti. That is why I said who. I didn't hear party. I heard
NDC party.
Order in court, please. Order.
You had issues. You raised issues with her appointment, not so?
Not that I recall.
Good.
Not that I recall.
Okay. And when the EC decided to have a new register, your party took the matter to court, not so?
I read that in the news.
Now, prior to the 7th December elections, your party variously raised issues about the performance of the chairperson of the EC, not so?
Can you repeat the question, please?
I'm saying that prior the events, the timing leading to the 7th December elections, your party and the petitioner raised issues about the performance of the chairperson of the EC, not so?
That I do recall.
Do you recall that?
Yes, I do. In great detail. In great detail.
Good. Now, in spite of that, you want this court and the people of Ghana to believe that the person that you have distrusted so much tells you to leave the strong room and go to the petitioner, and you left, both of you. Huh? Tell us.
My lords, there are two different issues here. I was asked by the petitioner to represent him with a team. I was there with Dr. Professor White to represent him in a very specific mandate. The presidential candidate, in spite of all the things you said, did not say he was withdrawing from the poll because of all the things you alluded to. He still took part in the elections. No. And as required by law, the returning officer was also supposed to be an independent returning officer, to be fair, to be transparent, and to run an election with integrity. So under those three principles, I was asked to go into the strong room to defend his interests to the best of my ability.
At IPAC, it was decided that each political party or each candidate will have at least 4 accreditations, with 2 in the strong room at every point in time. Is that correct?
That is correct.
Good. So it means that at the time that you were leaving to the petitioner's residence, you had two backup people who could represent the petitioner in the strong room, not so?
My lords, let me put it on record that on the 9th, no strong room activity was ongoing, and at the time that I went to see the Electoral Commissioner, we had 4 regions that had not been dealt with. We also had a situation where the Commissioner herself, performing her functions as the returning officer, directed the 2 of us to go and send a message to the petitioner. So long as he left, the functions of the representatives could not continue, because the other 2 would not have the same appreciation of the specific issues that we were dealing with. It's not like a relay race where you just hand over a baton. You must deal with the specific issues.
So you agree with me?
And she was minded by that. She knew that we were not in the strong room. She knew that she had directed us to leave, and she told us that she would give us a police escort to bring us back in time if we had traffic challenges. She knew.
You see, I am asking you again that at the time that you left, you had the opportunity to have 2 other people represent you in the strong room. Yes or no?
And I've answered you as follows, that in as much as we had 2 opportunities to replace the representatives, the specific issues for which we left the strong room were such that any other 2 people would not have the same appreciation of the issues, and therefore they could not continue to perform the functions as representatives of the petitioner in the strong room.
Now,
and that is a statement of fact.
So you are saying that in spite of the fact that it was agreed that you could replace, you in leaving decided not to be replaced. That is the case, not so?
That is not the case. In the case of the MPP, you had Magmeno, John Bwedu, and so many other people in the strong room, even though 2 people were supposed to have been only in the strong room at the time. Why is it that they were permitted to be in the room? Why were they permitted to be in the room?
Your answer reminds me of the parable. Anyway, my lords, I leave it. I leave it. Now, in your evidence in chief, you stated that you had been at the EC headquarters for 3 days and somebody brought you change of clothing, not so? A shirt.
That is correct.
Now, in the same witness statement, you said that when I arrived on the 9th, you said so, that when I arrived on the 9th, let me just go through it.
Which specific item are you dealing with?
Yes. The first paragraph I referred to was paragraph 26. The second one, paragraph 22. Paragraph
22.
Yes.
Yeah.
You said, the beginning, says that it was in the light of the experiences of different regional certification processes and the posture of the EC officials in the strong room on the 9th that, on behalf of my colleagues and myself, I sought to consult with the EC. I also needed to receive feedback on the conveys the previous day, particularly I had learned from the officials, particularly as I had learned from officials at the NDC headquarters before I got to the EC headquarters on the 9th. So you see that.
Yes, I've seen that.
Good. The two conflicting portions of your witness statement, can you clarify the court? Where were you coming from on the 9th? Where were you coming from?
In the early hours of the 9th, I was sacked from the EC strong room, and I had to drive from Accra all the way to Committee 25, where I reside. This was around 2 a.m. of the 9th. I then had to wake up very early and go through another 2 hours of traffic on that eastern corridor back to the EC office.
So, I'll leave this point. It is clear that you have not been a truthful witness, even on your own evidence in chief. I'm putting it to you that your evidence in chief is full of untruths, and if they are true, they are half-truths. I'm putting that to you.
Lord, with the greatest respect, the witness has not been shown untruths in his testimony such that the witness was just given an example. One example, when I arrived on the morning, the witness explained clearly he had to drive and so on.
It's not any damaging question. Which,
no,
you always put to witness that he's not being truthful. Yes. So please let it go.
Do you recall that on the 9th as well? Please, can you answer the question?
What is the question?
The question to you is that even in your witness statement, you have told the court untruths and half-truths. I put it to you.
That is absolutely untrue. Absolutely untrue.
Now,
I swore on oath to tell the truth, and I told the court nothing but the truth.
Now, do you recall that on the 9th, you granted again an interview to your favorite Kwesi Parker Wilson at the NDC headquarters?
Yes, I do recall.
Now, you recall you said...
yes.
You recall you said this, among others. Because I don't have the documentation in front of me, it is becoming a challenge for you to appreciate what I am saying, but create another opportunity for me and my other colleague in the EC, and we will show Ghanaians and the global community the fraud that has been perpetrated on the people of Ghana. Let me emphasize, President Nana Akufo-Addo did not win the presidential election. He did not. He did not. And I repeat emphatically, he did not. I was in the EC. I was representing the party in the EC. And I'm saying that on the face of the evidence provided, Nana Addo Dankwa did not win the election. You recall that?
Yes, and where in that statement does it show that I'm contradicting myself in terms of time?
No,
where?
I didn't ask you.
Mr. Rojo, please come straight. He is asking you whether you did grant that interview. It's very simple, you recall.
Yes, the answer is I granted the interview, yes. I granted the interview.
Now, I am putting it to you that even as of today that you are testifying, you have brought no such proof to the court. I'm putting it to you.
This is not a fact.
My Lord. Well. I am putting it to you that even as you speak, the petitioner has not brought any such proof to the court.
My lords, the petitioner is seeking very specific reliefs of the court. And the statement and interview I granted is not in evidence because the legal arguments of the petitioner does not require that at this stage. It's not one of the pleadings. He is specifically asking the returning officer to declare the true results of the 2020 poll. The 2020 poll, there has been one declaration, several press conferences or press releases, and there can be only one declaration. One declaration. And so the petitioner's response for me as a witness was to show my performance and presence in the EC strong room. That is what I was supposed to address.
Oh, we'll come to that. Mr. Robert Joseph Metonunu, you say in paragraph 31 of your witness statement that you are a veteran of the strong room since 1992, not so?
The longest serving representative of any political party.
Great. Now, is it the first time you have left your post to consult with your candidates, or you have engaged in the practice previously?
It is not the first time. It is not the first time. In my engagement with previous returning officers of the presidential poll, I had occasion to leave the strong room to go and speak to a person I was representing in the strong room. And then I returned with the understanding that I had been sent to do so. And in this particular instance, I had also been sent to do so.
Oh, so you want the court to believe that various chairpersons of the EC send you and you obey. Is that the position?
As and when it was necessary to do so. As and when, in order to resolve the issues. For example, in the election that took us to time, it was a result of the consultative process that was available to us that brought all the political parties to a meeting called by the EC chair to agree that the only way to resolve the issue of the deadlock was to have a by-election, a runoff in time.
And at all times when you are living, all of you, all the representatives or the agents of the candidate in the strong room leave without any backup representation. That is what you want this country to believe, and also.
That is the case, and that is what my testimony says. Okay. That is the case.
Now, you say that you identified issues in the strong room, not so? You identified issues that needed resolution in the strong room, not so?
Correct.
Now, should you not, as a representative of the candidate, not be in the strong room to do the work you are assigned to do?
Can you repeat that question again?
Should you not, as a representative of the candidate in the strong room, should you not have stayed in the strong room to do the work that he assigned you to do?
My lords, in the strong room, the activities of the presidential representative is to cooperate with the EC for the declaration of the true results. And as a team leader of the group, it was my responsibility to consult Dr. Sribopak. I consulted Mr. Tete, and then I also went to consult with the commissioner. And in all those situations, the EC's offices were not in one place. I spoke to Srebo Paku in the strong room. I spoke to Mr. Tete in Jean Mensah's office. And I spoke to Jean Mensah in her office.
Okay, that reminds me. When you went to Jean Mensah's office to speak to the people that you are speaking about, was she the one who invited you, or you left the strong room of your own volition?
I informed Dr. Srebo Paku that I was going to see the commissioner. I also informed Mr. Tete that I was going to see the commissioner. I did. And then when I made the phone call, to Jean Mensah, she invited me to come.
The question is, when you left the strong room to go and meet with the commissioner in her office, it was of your own volition, your own free will. Is that not so?
It was not just a simple matter of my own free will. It was a function of me being a representative of a presidential candidate, and in order to do my work properly, officially, it's not about my own free will. I was performing an official function. It is not about my own free will. I was performing an official function.
When you went, you were in that secretariat for close to 3 hours. Is that not so?
Because I was told to wait.
Answer the question.
I was told
in that secretariat for close to 3 hours.
I was told to wait, and it was for that reason that I was shown the reception area to her office, and I kept on waiting until 10. She asked me to wait for her in her office reception.
Mr. Chikata, may I have your attention? Please, can you let your witness be very, very, very specific, or brief on some of these simple issues? Very, 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 very simple. I don't know where he's dragging this. He was asking a simple question.
My Lord, I do not wish to interfere with the answers of the witness.
Yeah, I know. The witness is your witness. Here to help the court to elicit information to help us arrive at the truth.
Yes, my Lord, if you take the answer that he was in the process of giving, he says you were there for 3 hours, and he says he was there
Mr. Menbo, you go on.
Tell us how long you were there for.
I didn't hear the question.
Tell the court how long you were in the secretariat for.
Oh, it was a considerable length of time.
Yes.
Because the commissioner was not there, and
you had left the strong room, not so?
That is correct.
And even whilst there, you were offered tea and biscuits, not so?
I was offered tea. I wasn't offered any biscuits.
Order in court, please. Order, please.
I am putting it to you that on that occasion, as well as the 4 p.m. when you left the strong room, you did so on your own free will and volition.
That is not correct. It was not on my own free will.
Now, I am putting it to you that all the grievances stated in your witness statements are afterthoughts. They are afterthoughts. I am putting that to you.
That is not correct. The process of function in the strong room is a process. It's a process. And the issues that I was going to discuss with the EC Commissioner are issues arising out of the performance of my function in the strong room. How can they be afterthoughts?
I am further putting it to you.
How can they be afterthoughts?
I am further putting it to you that you couch them after you heard the wobbly testimonies of the first and second witnesses of the petitioner. I'm further putting it to you.
That is not correct. I am giving a testimony of my own performance as a team member representing the flag bearer. That is not correct.
You see, your witness statement and the evidence you have given is a bad explanation for the bad job that you did for the petitioner.
You are being judgmental. That is not fact. You are being judgmental. I was performing a function, and I was supposed to protect the interest of my candidate, my presidential candidate. And I did it based on my knowledge, past experience, and a certain sense of high maturity in the strong room. If I misconducted myself, this country would be involved by now. You need to appreciate that. It was my mature handling, my very mature handling of the situation. And don't forget, the EC chair said that she was going to declare the results in 24 hours. She said she was going to declare the results in 24 hours. And there were so many anomalies. So many anomalies.
Mr. Metonunu, having delivered your lecture, I want you to come back and answer my question. I'm saying that your witness statement is a bad explanation for the bad job you did for the petitioner.
And I'm saying that is not correct. You are not the chief examiner here. That is not correct.
Now, in order to hide your shortcomings, you went to the petitioner and to your party faithful and fed them on truths. I'm putting that to you.
My lords, it is your client that you are representing. It is your client that is being untruthful. She is supposed to declare credible election results.
Please,
multiple results. It is your client that is being untruthful to the people of Ghana, to the people of this republic.
Please listen to the question and answer. It's a very straightforward answer. Yes, he is asking you. He is putting it to you that we are not being truthful. Period.
And I said, I'm being truthful. I said, your lord, I said, I'm being truthful. And because he also preempted his statement with all those innuendos, and the fact that he was trying to impugn my integrity, I'm telling him that it is his client who is also being untruthful and is not telling the people of Ghana the true result of the elections.
You recall the 2008 conduct in the strong room. You remember?
Yes, I do remember.
When you said that I am Rojo Metonunu, and that if Kwabena Dupont didn't take his time, you are going to go at him one-on-one. You remember?
That is correct. And I told him that in the face because he was trying to change the results.
You see, I am putting it to you. He was trying to change the results. I am putting it to you that that character of yours is what you have just displayed for the court.
I have a temperament for fairness. I have a temperament for telling the truth. I have a temperament that makes me want to fight to defend the integrity of my name.
You have a temperament known as ungovernable character. My Lord, that will be all.
My Lord, do I have the right to respond?
Papa.
Yes, my lords.
Any cross-examination?
Definitely, my lords. Mr.
We will let you. We can take about an hour and a half, and then you'll rise so that the witness may have the opportunity to also rest for some time. No, please sit down. Yes, we cannot let him undergo cross-examination for continuous, several hours in this.
My lords, we understand that. Now, Mr. Metelnunu, I trust you are well.
I'm trying very well to respond to the court, but I am quite sick and I'm just getting better slowly.
Now, I believe that it was after the declaration of 9th December and the press release of 10th that the petitioner decided to challenge the declared results. Is that so?
After many years of undercover investigations, I bring you the sea. Issues that borders many Ghanaians and around the world. The politics.
Fully committed to being fair and impartial.
Current affairs.
The very survival of our nation is what is at stake in this effort that the soldiers are doing. They're not doing it just for themselves. They're doing it for all of us.
The investigations and crossfire.
Today, inshallah, there's no excuse for any student in the Zongo community not to have education.
The show is the seed.
Make a date with Kweku Anan on the seat of accountability, performance, and justice on Net2 television. Monday and Wednesday at 7:30 p.m. to 10:30 p.m. Repeated on Saturday and Sunday at 3 p.m. to 6 p.m. Net2 television, beyond the limit.
Let me advise you that you are before the Supreme Court, and when I put a question to you, the court expects you to answer the question, not to set up your own question and run around with it. So please listen carefully to my questions and answer them. Now,
my Lord, can I be clear? My Lord, can I be clear? If I answer a question with an initial statement and I need to throw more light on that answer, am I not permitted to do so?
You are not permitted to run irrelevant commentaries. That's what I'm trying to tell you. Now,
but how do you determine irrelevant commentaries?
Now, Mr. Metelnunu, this decision to go to court was after a number of civil society organizations and faith groups and prominent public voices had urged the petitioner to go to court if he did not accept the results of the declared elections.
I believe you also remember that the petition said you would not accept the fraud results.
You see, you have not answered my question. So please be respectful of the court and answer my question.
The question again.
I said the petitioner took the decision to go to court after a number of civil society organizations, faith groups, and prominent public voices had urged him to go to court if he did not accept the results of the declared elections.
That is not correct.
So the petitioner went to court before these calls on it. That's what you are suggesting.
The petitioner went to court on his own volition.
Now, I believe as a person with considerable experience in the former strong room, which is today called the National Coalition Center, you played an important role in the preparation of this petition. Is that right?
That is correct.
Can you tell the court?
No, hold on. The question again.
Now, Mr. Metonunu, can you tell the court exactly when the decision was taken by the petitioner to go to court?
I do not know exactly when the petitioner took the decision to go to court. I do not know exactly when he decided to go to court. I do not know that for a fact. But I do know that he took a decision that at a certain time he took court.
Around what time then, if you don't know the exact time? Around what time?
I am not privy to that because I have not been very well. So I'm not privy to that.
No. I also believe that the information you gave to the petitioner as to what happened in the strong room certainly contributed to the drafting of some of the paragraphs of the petition. Not so?
Some of the paragraphs
of the petition.
Of the petitioner?
Of the petition. We are in court because of the petition. You don't understand? You heard my question, so yes, but you heard the question.
Yeah, you can.
Yes,
you can. It's
that is what I mean. That is what I mean. You made an input. You, Mr. Yes. And right from the beginning, you were one of the witnesses the petitioner intended to call. Is that not correct?
That was one of the witnesses that was going to call?
Yes. Of course you
do. I have no idea who is going to call by the legal team. I have no idea.
Very well. So, when did you get to know that the petitioner was interested in calling you as a witness?
The legal team was finding out about my health condition.
Please.
And I cannot recall exactly when they called me, but there was an interaction with the legal team about my health and whether I would be able to do it. But I can't recall exactly when that happened.
Was it in late December, early January?
I really do not recall.
Really? I'm putting it to you that you have deliberately refused to recall when, because you are seeking to avoid telling the court the truth on this matter. the subject matter of your witness statement and how it came about.
Can you repeat what you said?
Mr. Matemunu, I would plead that you listen. I'm saying, putting it to you, that you have deliberately refused to tell the court when you got to know that you were going to be a witness in this case, because you seek to hide that factor, the circumstances surrounding your giving a witness statement in this matter. That's what I'm putting to you.
I'm refusing because I want to hide the circumstances around my being a witness?
Yes.
Your Lordship, you know me for many years. You know me to have a dubious character.
Indeed.
No, do you know me to have a dubious character?
Mr. Metonunu.
Please don't answer their questions with the question.
I'm waiting for your answer.
I am not hiding behind any condition of mine. I am not.
Okay. Are we free to address your conditions of health? With your consent, of course, that's what I mean.
Counsel for the petitioner informed us that the witness under oath was not also unwell, and we decided to, come to terms with the situation.
That is so.
That is why we are going through this.
My Lord,
have been here.
That's why I respectfully, my Lord, if I may.
So let's keep this. Let's keep this.
If I may be please be heard. The petitioner, in a letter dated 3rd February, the witness, 2021, states that I am waiving my right to privacy so that all my testimony is in public. And I want to know whether that waiver covers the conditions of his health. I want to understand. If it covers, if it doesn't, I don't have a problem. But if it does, then I'll be able, I can deal with that matter.
She wouldn't mind if it is on live telecast. That is my understanding. Maybe I'm wrong. So please, let's avoid this.
Very well, my Lord. Now, can you tell the court on 3rd February where you were? 3rd February 2021, where you were?
3rd February.
Yes.
I went for a medical review.
So where were you coming from to the medical review? That's what I mean.
That is the Belated Teaching Hospital.
Please, Mr. Metonunu, I'm asking, where did you come from to go to Kolebu? Where did you come from?
Where did I come from?
Yes.
I came from home.
Good. So, can you tell the court, how long have you been living at home since your condition?
Which specific medical condition are you referring to? Because I have several health challenges.
Very well. So, on the 4th of February 2021, I believe you were still at your personal residence.
Mr. Tuampao, where is this leading to? Is it really necessary? Is it directed at something? Where is this leading to?
Yeah. How questions are framed, the answers to it, so that we can, yes, have an informed opinion about some.
My lords, we are seeking to demonstrate to the court that the explanation given for this very belated witness statement is a ruse. That's what we are seeking to do. I'm not disputing that, my lord.
For this witness statement to come after this,
Now, very well, my lord. Now, I believe that from the beginning of February, you had access to the media, radio, TV, online streaming, didn't you?
I had access to
the media. You could listen to radio, you could watch TV, you should go online.
That is not entirely true. I needed to renew my DSTV license, and so I didn't have access to that one.
So, I'm furthermore putting it to you that you did listen to radio.
No, I do not listen to radio.
Good. So are you suggesting to this court that you had no interest in what was going on in this petition?
That is not correct. The fact that I don't watch television or listen to radio doesn't mean I'm not interested in the proceedings.
No, so you agree that you were interested in what was going on in the proceedings here?
Absolutely. As a representative of the petitioner in the strong room, I'm interested in the proceedings. I'm interested, very, very interested.
So you heard the proceedings as they unfolded in this court?
Some of them, not all, some of them.
Mr. Abuduampa.
Yes, my lord.
What is the position of the law? Assuming even he sat here.
Yes.
And my lord, and wait, and heard the evidence.
Yes.
Does it disqualify him?
At all, but please, my lord, but it enables the court to take note of that it was a witness that had heard the proceedings before testifying. That is the important thing. That is the very important thing I'm trying to arrive at. And we all know that this is a matter that the court will and must take into consideration. The witness that sits in court hears the proceedings and then comes to give evidence. Now, I want you to explain to this court how come your original witness statement of truth referred to paragraphs 1 to 22?
Mr. Kutempa, we've gone beyond that. You see, the permission was sought for amendment, and we accordingly granted it.
Yes, I'm all.
You see, you are a veteran in this job. Do you allow your witnesses to prepare this statement of truth? No, I'm asking you as a lawyer of some standing.
Yes.
Do you prepare this statement of truth, or you allow the witnesses to prepare?
My lord, the last time...
No, answer that question.
We don't, but I make sure the witness reads what we prepared.
No, but petty errors may occur, and they occur on a regular basis. That is why we allowed this amendment to be granted. So we've gone beyond that.
My lords, I'm most grateful that the court recognizes the occurrence of petty errors. Now, you said in paragraph 8 of your witness statement that, quote, Dr. Professor White and I on many occasions pointed out errors in figures and words on the sheets that were brought, which ultimately affected totals and assigned results. Now, when the petitioner filed his petition, the only problems he complained about were the complaints in his Exhibit B attached to the petition, the alleged padding complained of in Exhibit F, and his exhibits and his exhibit, I believe, E.
How can the witness have access to the pleadings?
Well, the witness,
he said he gave information for the preparation. That was what I understood him. But looking at the pleading, how many witnesses would have access to the pleadings settled by counsel?
My lord,
no, in fairness to the witness.
My lord, the witness has not said he is unable
you see,
to answer this question.
Well, go on.
My lord,
excuse me, is to also protect every witness who comes to testify. Yes.
my lords, indeed, the witness has made clear that he had an input, but he does not know the details of what the lawyers did. I think he gave an answer to that effect. And this question is referring to exhibits and so on in the pleadings. And I do not think that it's appropriate for the witness to be asked questions in relation to a petition. If he wants me to go into the witness box to answer questions about how the pleadings were made, we can determine whether
I take very serious objection to this snide remark. No, I take very serious objection to it.
My lord, I will avoid sarcasm, and I take that back. I take that back. But my lord,
Now, You know that the regional secretary in Ashanti clearly indicated that they had no problems with Ashanti region results, but rather rejoiced at the results. Don't you?
The question again, please.
I said, you know that your regional secretary, that is the NDC regional secretary for Ashanti, had stated in public that he had no problems with the results of Ashanti region, but rather he rejoiced at the results.
I am not aware that the regional secretary for Ashanti has made any such statement. I'm not aware.
But you are again aware. You are present at the Regional Coalition Center at Ashanti.
I said I'm not aware. So how can I be again aware? I said I'm not aware.
Materino, he's asking another question. So please don't lose focus. Just listen. Yes.
Okay.
Yeah. Okay. He's asking another question.
You are again aware that present at the Regional Coalition Center of Ashanti were stalwarts of your party, including Mrs. Betty Mould Idrisu. Not so?
I knew she was in Ashanti region, but I didn't know she was present at that particular time in the regional whatever coalition center. I have no knowledge of that.
And I'm putting it to you that she did not complain about the figures of Ashanti.
I am not aware of that. I am not. And she was not the returning officer, sorry, she was not the representative of the region in that regard.
Now, I'm furthermore putting it to you that the complaints that the petitioner has in respect of Ashanti region related to only 4 constituencies. I'm putting it to you.
That is not correct.
And I'm furthermore putting it to you that the numbers involved were a mere 534 votes. A mere 534 votes.
That again is not correct.
And furthermore put it to you that this number had no material effect on the overall outcome of the presidential election.
To start with, I don't know where you're getting these figures from. And I have no way of confirming that the figures and the source of the data is correct. I have no idea where you're getting these figures from.
Now, one of your complaints in your witness statement relates to the Eastern Region summary sheet. Is that not correct?
That is correct.
Now, you will notice that your complaint was that there were 2 summary sheets, one signed by the NDC and other agents of the other candidates, and the other, those signed by agents of some of the other candidates, was not signed by NDC.
Yes, there were 2 summary sheets presented. 2. two summary sheets presented. One was signed by the NDC, and the other was not signed. That is correct.
Now, I'm putting it to you that the fact that the other summary sheet was not signed by the NDC does not prevent the chair of the EC to rely on it, provided they were signed by other parties.
Is it not a question of law?
Well, that he makes a case out of it. That is the point. So,
now, my lords, if I may, that exactly is the issue that we were raising. That on many occasions, the EC permitted the resubmission.
Intervened to expunge the question. So there's no question now. So listen to counsel.
There's no question to be asked.
Yeah, he'll come back to you.
I'm sorry, my lord. I'm sorry.
Don't worry.
I'm extremely sorry.
Now, in paragraph 10 of your witness statement, you claim that the EC officials were applying double standards, correcting signed summary sheets from the regions on occasion, while refusing to correct others on the ground that the agents or the candidate had signed. Is that not it? Is that not
That is absolute point I'm making. Yes, that's a point I'm making in my statement.
Yes. I'm putting it to you that Dr. Pesa White, who was with you at the National Coalition Center, made no such reference in his witness statement.
Well, I wouldn't know what he said in his witness statement, but in my candid opinion, in fact, I was watching the fax machines, and on many occasions the fax machines were not attended to because no faxes were coming. And then suddenly you see something coming, and then you have to...
Please, Mr. Rojometo, at times you talk too much. Mr. Kutampa.
Yes, my lord.
I'm a politician and a former lecturer. That's why I'm like that. I'm sorry.
Let me remind you, you are in a courtroom. So please mind the way you answer the questions. Mr. Kutampa, if two persons witness the same incident and you ask them to narrate what they witnessed, they will come with different stories. Natural, you see, natural. So the fact that one witness did not, make mention of something, it doesn't mean another witness will make mention of the other thing.
Yes, my lord,
you understand it?
That is generally true. But where the matter is...
You see, more so, it should be presumed that he doesn't have access to the witness statement of Dr. Pasawat.
Yes, but my lord, I'm putting it to him. So if he says he doesn't know, it's on record that he doesn't know. That's what I'm doing.
But the question must be, with no respect to me, a legitimate one.
Now, in any event, from your long experience since 1992 in the then strong room, now National Coalition Center, you know that even where agents of candidates disagree with the figure, the EC may go ahead and use the results to declare the elections. You know that from your experience.
That is not always the case.
Good.
In most cases, depending on who the returning officer is, you were giving an opportunity for correction before the final declaration. In this particular instance, the EC chair is not following best practices.
You see, I'm putting it to you that the agents of the parties cannot compel the EC to do their will.
The agents of the parties cannot compel the EC, that's correct. But that is why in the past we had an iPad. The iPad provided an opportunity for further stakeholder dialogue.
Now, we claim in paragraph 19 of your witness statement that you made a mistake when you signed the summary sheet in the strong room. Is that not so?
That is correct.
I'm putting it to you that whether or not you made a mistake, the EC was entitled to process that summary sheet.
That was not always.
Is it not a matter of law?
My lord, that was not always the case.
Oh, Mr. Metununu, please. Yeah.
I think there's a time lag.
Yes, I know. There's a problem. Some few seconds can. Yes, but I thought that it is covered by the CI.
What is covered by?
Your question?
Yes.
It is covered by the CI.
Yes.
Yes. Yes. You see.
Excuse me. My Lord, the witness, I'm relying on his experience. And my point is, the point I'm making.
And what his experience teaches us is the regulations in the CI. Yes, that is what we understand from the bench.
In other words, his experience does not surpass
the CI.
This CI.
Everything is in the.
We are guided by this.
Very well. Now, we refer in paragraph 17 of your witness statement to a difference of 1,707 votes between the original summary sheet presented to you in the strong room and the one published on the EC's website. Now, I'm putting it to you that 1,707 votes, even if true, do not have any material effect on the final outcome of the elections.
My Lord, that is not correct. The Electoral Commissioner has not accounted, she has not accounted for the votes and how they were tabulated. She has not. Little drops of water makes a mighty ocean. So she has not established the true number of votes cast and all that. Yes.
Now, you refer to Western North summary sheet in your petition, in your witness statement.
Western North, that's correct.
And claim that the petitioner's agent refused to sign. One also.
And claim that the petitioner did what?
The agent at the regional center did not sign.
Yeah, did not sign.
But you signed.
That is correct.
Good. Now, just for the education of the court and myself, what exactly was the information you were taking to former President Mahama, the petitioner? I'm not saying what message the EC chair gave you, but the substantive information you were taking to President Mahama, former President Mahama. What was that?
The specific message that I was directed sent.
Mr. Metonunu, I'm not asking you the message that anybody gave you. I'm saying what was the information that you were going to give to President Mahama on that day?
The information I was going to give related to anomalies that we had detected in the processing of summary sheets from the regions and how the collation process was taking place in the strong room. Anomalies in mathematics, anomalies in words, anomalies in totals and tallies. Yes, those were the issues.
So I'm suggesting to you that the EC chairperson could still have gone ahead with the processes of declaration, whether or not you sent any message or information to President Mahama about any anomalies.
My Lord, again, I think this is a question of law. I mean, it's clear.
Mr. Kutapa.
Yes.
All rise.
My Lord, I was misled by your calling me, you know.
Mr. Nunu, please turn your camera on.
Everything is on.
Now, Mr. Nunu, I'm putting it to you that the matter you said you were going to inform the petitioner in respect of was a matter that you could have discussed with him on the phone, especially at the critical time of collation at the National Collation Center. I'm putting it to you.
Is it a statement or a question?
I'm putting it to you.
That is not correct.
I'm furthermore putting it to you that you had a working phone with you at the time.
The question again?
I'm putting it to you that you had a functioning phone with you at the time you were leaving the National Collation Center.
You said what with me?
A functioning mobile phone.
Yes, I had an iPhone that was functioning.
Yes. And indeed, it was the same phone that you allege you used in an attempt to reach the EC chair.
At various times, yes. In some instances, I got her, and at other times, her phone was off.
Now, I'm putting it to you that nowhere in your witness statement do you demonstrate with numbers how your alleged errors in the figures impacted in any material way the final outcome of the 2020 presidential elections. Nowhere.
My Lord, it's not a matter of figures. It's not a matter of figures being put in my witness statements. It has more to do with a trend of anomalies, several anomalies. And we were seeking a forum for a proper presentation of those issues.
Okay.
We were seeking a forum for the proper presentation of those issues.
Well,
for example,
well said.
Can I give an example?
You can't give examples here. Now,
for an example.
Now I'm referring.
Respectfully, why can he not give an example?
Because I'm referring to his witness statement.
He's cross-examining. The witness is saying, I want to give an example to explain my answer. Why is that disallowed?
Mr. Metununu, you can go ahead with your examples.
My Lord, for example, the Eastern Region 2 summary sheets that were presented, the total number of valid votes as recorded on those two sheets was the same. But in one of them, Nanado had much higher figures being attributed to him. The petitioner's votes were reduced, and similarly, all the other presidential candidates also had their figures reduced. But the totals of that second summary sheet was the same. That was the specific fraud. That was the specific manipulation. That was the specific anomalies that we're referring to. How is it possible that the same regional office can submit two separate results? On the face of it, the total votes cast the same, but then the vote attributed to each of the candidates was taken. And in one of them, our candidate was not present to sign or to vet or verify. And then you are tendering both of them. Which of them is the original and which of them is the genuine result? Which of them? In another instance, you have a whole constituency, the results not recorded, and yet the summary sheet has been submitted by the EC regional representative of the returning officer. And if I sign that in error, and I come back and tell you that I have observed that that is in error, why can you not address it? Because the regional summary must have 100% of all the constituencies' results as tabulated, and not that you have one omitted. It cannot stand as a summary. And in the same instance of examples, I observed several of those summary sheets having errors in figures and words which affected the summary of the total.
Yes.
Several of them.
So my point here is that you have not given this court the details of the figure as to affect the outcome of the elections. That's the point I'm making. I'm putting it to you.
My Lord, the question is muffled.
Have you not given
it? The question is muffled. I can't hear the question properly.
I'm saying, putting it to you, that you have not presented to this court the details of the figures that have a material effect on the overall outcome of the 2020 presidential elections. That's what I'm putting to you. And it's on the
My Lords,
of the record.
My Lords, I have alluded to anomalies that, if tabulated, would add up to the figures. I have raised in my statement of 32 points that in specific anomalies that I noted, this was the case. How is it that that does not refer to figures? I may not have given you specific figures, but I've given you instances in Ashanti, in Eastern region, in Bono East, in Northern region, in Greater Accra, in Eastern region, where these things have been seen and noted. It's a reference to the mathematical infractions. It's a reference. And if the court was well, please, you ask the question. The candidates you represent, have benefited hugely from these anomalies that I'm referring to, benefited, and that resulted in the board result that was declared.
See, I don't know. The whole of your cross-examination is on I put it to you, I put it to you, I put it to you. I'm wondering whether that's all that lawyers do in a courtroom. I put it to you, I put it to you, I put it to you.
My Lord.
Because this is cross-examination.
Yes, my Lord.
And what I'm expecting is witness control.
Yes, my Lord.
And because there's no witness control, that's why the witness is going on a tangent. And I don't know how many more I put it to use you have before we close this.
My Lord, the record of his evidence is before the court. If I put it to him and he says something else, that is a journey in futility.
But why not exercise witness control? There's a way in cross-examination to control the witness. to agree with what you want the witness rather than to leave the witness and to go on a tangent, because we can continue with this for the next.
So, Mr. Metalunu, you see, in the eastern region, you will see from the record that a whole constituency's vote was omitted in the first summary sheet of the region. So what happens in the second summary sheet was...
Well, respectfully, the counsel cannot give evidence. Counsel cannot give evidence. What happened in the second sheet, that's evidence. It cannot be allowed as a question.
See, Mr. Metalunu, the first witness of the petitioner appeared before this court and admitted to the correctness of the second summary sheet for Eastern Region.
My Lord, that is not an accurate account of that first witness's cross-examination. In any case, that witness
for address, please.
No. Mr. Metalunu, I am saying that you should take a look at the two summary sheets from Eastern Region.
Which summary sheet are you referring to?
The Eastern Region summary sheets.
You must refer to a specific time of transmission, because that will tell me which one. Is it the summary sheet? Is it a summary sheet
listen to
that was collated at 9:39 a.m.? Is that the summary sheet of 9:39 a.m.?
Mr. Metalunu, you said there were two summary sheets from the Eastern Region. The lawyer is asking you a very simple question. He says, look at the two summary sheets from Eastern Region. You look at it, and maybe the question will follow. You don't go off like we are going. You not even finish today the way you want to over-elaborate on some of these simple matters. He said, just look at the two summary sheets from Eastern Region. Then you leave him to follow up with his question. That is all. If it is not before you,
very well.
If it is before you,
very well, my lord. Very well, my lord.
Now you will notice that in the first summary sheet, which you signed, you have as the total valid votes 1,196,751 as the total valid votes.
That is not what I have in front of me. The total valid votes here is 1,236,940.
So just pay attention. You see, on the second but last column, you see 1,196,751. Done also.
I am not sure I am seeing what you are talking about.
I'm talking about the second but last column of the columns on that summary sheet. Second but last column.
My Lord, I cannot see the specific reference to which you are. I cannot see it.
Where you have total valid votes. Second but last column. or you have total valid
But
votes.
also, I think it will help all of us if we know exactly what document is being referred to, because I think we really...
Yes.
And if we...
Let me see where we are going.
Two are attached to Mr. Sejun Ketia's witness statement.
He may not have.
Yes.
There are two different times. Yes.
So mention which one you are referring to. So the witness will know.
I'm referring to it's not this 8:56 a.m. p.m. Sorry, it's 8:56 p.m. on the 8th of December.
The documents, yes, they're referring to Asidun. This is in reference to Asidun Kitia's witness statement. And in reference to that witness statement, to the extent that it relates to Eastern region, I do not see the 8-something p.m. Yeah.
Mr. Akotampa. One.
Yeah, exactly.
9:39.
Exactly. Exactly. That is what we also have.
Yeah.
My learned friend has it. I'm sorry. Yes, but I'm saying apparently he has a different one because he's quoting from a document which he says showed up at 8-something.
No.
That's what he said.
My Lord,
maybe he can show us the 8 p.m. one so that we see whether it fits with anything that we have.
my Lord, that's the first document.
Mr. Kotambo.
Yes, my lady.
Mr. Sidon pretended to
Yes.
headed Eastern region. Both were signed by the Regional Coalition Officer Faith Amejake. Is that what you have?
Yes, my Lord. There is the one with the blue stamp.
That's 9:39.
That's the 9:31.
Yeah.
9:39
Yes.
a.m.
And then there's an earlier one.
No, we don't have an earlier one. We have a later one which is 6:40 p.m.
The 8th on it is the date.
Yes.
8/12/2020 is a date.
Yes. Which is 6:40 a.m.
Yes.
40 p.m.
It's
p.m. p.m.
Put on your spectacles, Mr. Kotambo.
Oh. My lady, I think that
I was only teasing. It's
something different from what we are speaking to.
no, my Lord, we do not. Now, our point is, if one were to add yes, my Lord, if one were to add all the figures attributed to the different candidates, one with the blue mark.
That's 939.
Yes. Which does not have your signature. You arrive at 1,236,440. 940, sorry. Is that correct? Is that correct? Yes. But my lords, because there is an error of addition. And go through them.
My lords, that is correct.
Yes.
You will get 1,236,940.
Very well. Now, if you take the summary sheet that you signed and you do the addition of the actual figures, you will see that it is less 40,189 of the 1,236,940. In other words, if you add all the figures, the votes that the candidates obtain, you will get a total which is less of 1,236,940.
I think you're overloading your question. You should break it down.
Okay. So I'm putting it to you that if you add all the figures on the sheet that you signed, you get a total of 1,196,751. That's the actual total you get.
My lords, if I may.
Go ahead.
If you look at the totals without looking at the attributed figures to each candidate, you'll be making a big mistake.
Asking you the figure that you get. Please, when you respond to it, then you can give your commentary.
That is correct. That is correct. Can I go on now with the explanation?
Hold on. So
on the 9:39 a.m. figure, you find that they gave to Nana Addo 752,061, and on another sheet he gets 729,146. But the total number of votes cast is the same. The total number of votes cast in the two documents in contention are the same.
So just take your time. So I'm saying
the total of votes cast is the same.
Yes, hold on. I'm saying that the difference between the 1,196,751 and the 1,236,940 is 40,189. That's the difference.
That is the case.
Yes. And that figure of votes is exactly the total valid votes cast in Asensuano, Ahinsiano.
Mr. Akutuamba.
Yes.
You did this with the Mr. Asidun Kitia.
Yes.
So what are you trying to do now? Get something different, or to corroborate him, or what?
My Lord, that's why I put it to him, that this was, as Asidun Kitia actually admitted that there was an error. Very well.
It's not the admission. Yeah, and to add up, Mr. Asidun Kitia, it was he who attached these documents to his witness statement.
Yes.
You have cross-examined him on it. He has admitted the difference. Mr. Metununu has not attached any such thing to his witness statement. Right. Why do you cross-examine him on somebody else's documents?
No, my Lord, he referred to it in his response. That's why. No. So, you see, I am suggesting to you that nowhere in your witness statement do you show how your alleged lack of transparency and consultation had an impact on the final outcome of the elections. You have not shown it.
My Lord, that is correct. But I made an aversion that there were anomalies, that there were serious anomalies.
My Lord, that will be all for the witness.
No re-examination.
There will be some few questions from the bench.
Good. Mr. Rojo Metunono, you have admitted in this court that you left at a point in time to go and see the petitioner. Is that so?
That is correct, my Lord.
You have also admitted that you signed most of the summary sheets, the original summary sheets, 13 of them. Out of 16.
That is correct.
Good. Now, did you sign these summary sheets before you left to see the petitioner?
Yes, I did sign the 13th before going to see the petitioner.
Okay, thank you.
Can the witness be discharged, Your Lordships?
By court, PW3 is discharged as a witness.
Most grateful. That is the end of our case.
Okay. By court, the case for the petitioner is closed. Yes. Yes, Mr. Aminuvo.
My Lord, with respect, It's our submission that in view of the evidence led by the witnesses of the petitioner and our cross-examination so far, speaking for the first respondent, I'm of the view that there is sufficient evidence before the court for this petition to be determined. And therefore, my lords, yes, my lord, I was saying that giving the evidence of the petitioner's witnesses and the cross-examination so far, of those witnesses, my lords, speaking for the first respondent. Yes, my lords, it is the first respondent's case that we do not wish to lead any further evidence, and therefore we are praying that this matter proceeds under Order 36, Rule 4.3 and CI 87 Rule 3E5, and we hereby, on that basis, close our case. That is so. That is so.
Mr. Menuvo,
yes, my lord.
What then happens to your witness statement?
Well, my lord, under CI,
you file a witness statement.
Yes, my lord.
And the witness statement is supposed to be subjected, it's going to stand as your evidence in chief.
Yes, my lord.
And therefore, it's supposed to be subjected to cross-examination.
Yes. My lord, under CI 87 Rule 3E5, where if a party who has served a witness statement does not call the witness to give evidence at the trial or put a witness statement in as hearsay evidence, any other party may put that witness statement in as hearsay evidence. So, my lords, we are saying that we are not calling any further witness. If the court decides to treat our witness statement as hearsay evidence, well, the court is entitled to, but we are not leading any further evidence. We are not calling evidence.
The rules say the court can treat it as hearsay. So any party?
No, the party, a party, not the court. Sorry.
Not the court. Yeah.
The other side can treat it as such. Thank you.
My lords, respectfully, we need to understand the nature of what is being put forward clearly.
In a nutshell, it is a submission that giving the evidence from the petitioner to a petitioner's witnesses and the cross-examination so far, speaking for the first respondent, we do not wish to lead any evidence. We submit that we are not calling any evidence and close our case. Then he refers to Order 36.
Order. You refer to Order 36. Yes, sir. Order 36.
My lords, Order 36, Rule 4.3, with your kind permission, if I may read. Where the defendant elects of CI 47, my lords. Yeah. Where the defendant elects not to adduce evidence, then whether or not the defendant has in the course of cross-examination of a witness for the plaintiff or otherwise put in a document, the plaintiff may, after the evidence on behalf of the plaintiff has been given, close the plaintiff's case, and the defendant may then state the case for the defendant.
respectfully.
Yes, my Lord, CI 87 on what will happen to the witness statement if you choose not to enter the box, my Lords. Rule 3, that's sub-rule 3E, sub 5.
The alternative is to have
it is our respectful submission that counsel for the first respondent does not have it open to him to take the course that he just proposed to this court. Order 36 Rule 4(3) that he refers to specifically says where the defendant elects not to adduce evidence. In these proceedings, the defendant has put in a witness statement. So, my Lord, I'm sorry.
Yet evidence. It is just a statement.
My lords, what this provision says, where they elect not to adduce evidence. And what I'm saying is that the election that they made to submit the witness statement to the court is a clear indication that they made an election to the contrary. Because, my lords, in these proceedings, at the point of case management, your lordships basically asked questions from all the parties as regards witnesses being called. And it is at the point of case management where such an election is notified to the court. At that point, they elected to submit a witness statement. Now, that witness statement is not yet in evidence. That is true, but this is referring to an election. The point of election came at the point of the case management, and we are respectfully submitting that this witness cannot run away from cross-examination when they have elected. My Lord, when they have elected, that is the point. They have elected to the language, please. Well, my Lord,
maybe you can
my Lord,
but run away.
My Lord,
it is being a telecast, and people may interpret it.
I will adopt your words. So if your lordship,
yeah, he's evading.
Evading, my lords. I will totally adopt your lordship. I will totally.
Yeah, please, you have the opportunity to. Yes.
Yes. Assuming we were not dealing with witness statements.
I'm sorry.
Assuming we were not dealing with witness statements, and we were giving oral viva voce evidence, when would you say that a party has elected not to give evidence? Assuming we are not using witness statements.
At the case management stage. If the party at the case management, my Lord, at the case management stage, the party may, no, otherwise the case management stage is meaningless.
No. If a party is called upon to testify, and then he tells the court, I do not intend to testify, that is when we will say that the party is not willing to adduce evidence.
My Lord, respectfully, that is not the situation under the rules as amended to provide for case management.
Order 36 is proceedings at trial. So we have moved into trial stage. Order 36 deals with proceedings at trial.
I appreciate that, and the point I'm making is that Order 36 is premised on where the defendant elects not to adduce evidence. So, my lords, what I'm saying respectfully is that in the context, Order CI 47 obviously precedes CI 87. And in the context of CI 87 and the provisions for case management, the case management context is a context in which, for the purpose of a trial, the judge asks the parties how they are going to proceed. That's what I understand case management. Your lordships have had many occasions to point out the significance of the case management process. And my respectful submission is that it is in that case management process where, one, the party gives an indication to the court that I intend to call these witnesses. Now, if the party gives that indication, then respectfully, the party has made an election to adduce evidence. And my lords, that is the basis on which the court made orders at the stage of case management as to when witness statements should be put in. The court made orders on the basis of the election that they had.
No, Mr. Giza, point of correction. The orders for witness statements is made at the application for direction stage and not at the case management.
The orders
is made on the order 32.
Yes,
at the application for direction stage.
But my lord, that is the situation here is different from the pure high court situation, because in this case, at the case management stage, in this situation, we did not have a direct application for directions, my lord. We did not have that. I believe that's common ground between us. So in this case, we moved to the case management stage. And in the case management stage, the court makes orders on the basis of representations that are made to the court by the parties. And respectfully, the representation that was made to the court at that stage is that we are going to call a witness, and we will provide a witness statement on behalf of that witness. That's the clear indication that they gave. Otherwise, the court would not have made an order, submit your witness statement by such and such a date. That is very clear, my lord.
I wish to come in, Mr. Chikata. Now, are you saying that if you decide to call 5 or 6 witnesses and you put in 5 or 6 witness statements, you cannot at any point in time tell the court that though you have put in 6 witness statements, you are not going to call all the 6? Can't you say that?
My lords, you can say that.
Yes, please.
My lords, you can say that, but that is not what is dealt with in Order 36.3, which is what they're coming.
You see, under the normal civil procedure, if the prosecution closes its case, and that may be the plaintiffs, that's what I'm using prosecution in the civil sense, for the plaintiffs.
My lords, with the greatest respect, yes, let's just stick to what we're familiar with. If you say prosecution in the civil...
Okay, so if the plaintiff closes his case, and the defendant realizes that the case the plaintiff has made has no substance, or does not establish the reliefs he is claiming, and there will be no need for him to testify, you know, he can tell the court that he will not testify. And then he will be put to his election. Whether, if the court rules in respect of his application, he will still testify or he will not testify.
My Lord,
that is the procedure.
My Lord, with the greatest respect, that is not the procedure under our rules. With the greatest respect, that procedure may apply under the English civil procedure rules, but it does not apply under our rules. And with the greatest respect, if I'm wrong in that, I would stand to be corrected. Which rule under our rules has that provision?
It's a settled practice.
My Lord,
that we adopt. So are you saying that, my Lord, a party cannot say that I will not testify, judge the case according to the evidence you have?
My Lord,
because you cannot compare anybody to testify.
My Lord, with the greatest respect, my Lord, with the greatest
order in court, please.
With the greatest respect, I wish to take it a step at a time. If your Lordship is referring to a submission of no case at the end of testimony, if that's what your Lordship is adverting to, my respectful submission is that, one, under English common law, it is in fact not available in a trial which is not before the jury. Under common law, the authorities are clear that that process that your Lordship just described is not available. And I am prepared to cite some authorities in the common law which make that clear, including a well-known case of Alexander and Rayson. But, my Lord, before coming to that, I just wish to clarify that the common law position is very clear. Where there is a jury, it is open under the common law. Where there's a jury, it is open for Where there's a jury, it is open for the plaintiff to say, indeed, that I don't want the matter to go before the jury. I'm ending at the point of the trial judge. But the common law position that has been clearly stated in the English Court of Appeal is that where there is only a judge and not a jury, that procedure is unacceptable. And there's a very clear reason given for it in the authorities, which I'll come to. But, my Lord, I want to...
Mr. Chiket, I want to understand something. Are you suggesting that a party can be compelled to give evidence?
My Lord, that is not what I'm suggesting. I'm just suggesting that Order 36, Rule 3, applies in terms of the precondition that is put there. In terms of the precondition, it says where the defendant elects not to adduce evidence, then whether or not the defendant, and I'm saying respectfully that in this case, the first respondent elected to give evidence and notify the court as such. The first defendant elected to give evidence, notify the court as such, and on that basis, the court made an order for a witness statement to be provided.
Mr. Chikata, you are aware that at case management stage, nobody knows the evidence that the others bring. It is after case management orders that the testimonies come in. Is that not it?
Very clear. I mean that's a matter of chronological necessity, because that is a chronological necessity. A case management happens before witnesses are called to testify, so there can't be any doubts about that. I'm referring to the fact that under Order 36.3, which counsel for the first defendant is seeking to come under. And, my Lord, this is also different from the submission of no case under the common law.
Excuse me. Order 36 or sub-rules 2 and 3 together. It is subject to sub-rules. The plaintiff shall begin by opening the plaintiff's case. Then 2, where the defendant elects not to adduce, 3, where the defendant elects not to adduce evidence. It presupposes that the plaintiff has finished his case. That is my understanding. I stand to be corrected.
My Lord, respectfully, that cannot. Respectfully, that cannot be the case. Because, my Lord, Order 36 for 3, and respectfully, as I said, those rules predated CI 87 on case management. CI 87 introduces case management on the basis of which your lordships have proceeded and given orders. And respectfully, I'm submitting that under the terms of CI 47 Order 36 Rule 3, where the defendant elects not to adduce evidence is a precondition for that. And in this case, the defendant at the case management stage represented that they would adduce evidence, and therefore that precondition does not exist. And the defendant made those representations to the court and to the court in a manner which led your lordships to determine.
Mr. Chikata, may I seek clarification?
Yes, my lord.
Are you suggesting that under the case management regime, a defendant who indicates to the court before evidence is taken that I will call 1 or 2 witnesses in this matter, then after the plaintiff has given evidence, the defendant says, I don't think I need to call any evidence. Determine the matter on the basis of what the plaintiff has brought. Cannot do so?
Yes, my lord, I'm saying that he cannot do so where the court, on the basis of their representation, has ordered witness statements to be submitted. Because where he does that, he has elected other than what is provided for in Order 3643. Where he makes that election at the case management stage, and the court has made an order appropriately.
Mr. Secretary, whereas Order 36 Rule 4 is only regulating order of speeches.
My lord, I didn't quite.
Order 36 Rule 4.
Yes, that's the
next. Only regulating the order of speeches. That's all that the rule is seeking to do. But I try.
Yes, but my lord.
But how can the law state that a party compel a party to give evidence by all means?
No, my lords, respectfully, if you say that the order of speeches is all that.
Yes, order of speeches.
Yes, my lords, that's a head note, and your lordship knows very well that the head note does not settle the interpretation of the provisions. I mean, Bernard Mona's case is a classic instance where the head note was shown to be completely different. And in fact, if we were only dealing with order of speeches, then my learned friend is completely out of court, because if that provision is only to do with order of speeches, then he cannot, on the basis of that, be asking your lordships to do or be telling the court what he told the court. If it's just order of speeches, then it will be interpreted as such. So it cannot be just order of speeches.
These proceedings are...
I'm sorry.
Of Order 36. These with proceedings are tracked.
Yes, but Order 36.4, as his lordship pointed out, is order of speeches. That's what your lordship pointed out to me, and I agree. It says order of speeches. And I'm saying that the head note cannot limit the terms of that order, respectfully, because in fact, if your position were to be accepted, respectfully, then you should throw him out of court completely, because we are not yet at the point of order of speeches. We are not yet at that point. So if all that 36 Rule 4.3 is dealing with is order of speeches, then all he said is irrelevant, because we're not yet at order of speeches. But the reality of the matter is that that head note cannot limit the terms of Order 3603. I believe that.
Mr. Chikasa, isn't compelling someone to testify a human rights question?
Also, my lords, I'm sorry, my lords, this is new territory. I mean, I have to think about it because frankly,
nobody can compel a party to testify.
My lords, frankly, I have to give considerable thought. In fact, yes, I have to give considerable thought to what you're saying, that you're not...
I mean, as I'm sitting here, I'm reviewing this whole thing.
Yes.
I mean, nobody can compel a party to testify.
My lord...
That's a very basic rule.
My lady, as I said, I mean, your ladyship has been part of a ruling in this court which said the right to vote is part of the directive principles of state policy.
Chikata, please, may I have your attention?
Yes.
Please, none of us, at least those on the bench, none of us anticipated this step. That is.
Exactly.
So please come, both of you come and address us on this point tomorrow. Then you will give a ruling on it and then proceed accordingly.
My lords, I was actually going to make a similar submission because it is my respectful submission that for an application of this nature under Order 19, it should be made in terms of a motion paper and a supporting affidavit so that we can respond appropriately. Because, my lord, that application that is being made...
Please, with all respect, please, there's nothing factual about this application. Yes. Let's take it. If he comes tomorrow to raise this legal issue, you have the opportunity to reply. So please, just prepare.
Very well.
And bear with us tomorrow.
Very well. Very well.
Yes. Please, we want to know your position because you have also filed a witness statement.
Yes. My lords, we do not intend to call any witness.
Okay, then you prepare.
And my lord, let me complete.
Order.
We do not intend to call any witness because, in our view, they have not satisfied the burden of proof. So we can't be forced to call any witness.
Please, we don't want lengthy answers. Please, what we want you to do is to prepare, come and address us on it tomorrow. Then we will give a reasoned ruling on it and proceed accordingly. Thank you very much. Please, you will rise for the day.
I know.
Please be seated. Be seated, please.
Please, attention of the bench has been drawn to the fact that immediately after proceedings, counsel from both sides resort to granting interviews to the media. And at times, some of them keep on twisting the facts, which actually occurred in the court and seek to even prejudice whatever the court proceedings were. So lawyers who are engaged in it are to please have a look at Regulation 55 of LI 2423. Yes, that is the legal profession etiquette, conduct and etiquette rules. Please, if I may read 55C. So, a lawyer shall not publish or cause to be published a material concerning current or potential proceedings, including proceedings for which the lawyer is engaged or seeks to be engaged, which is inaccurate or has received comment or necessary description. Then C, is calculated or is likely to a material degree to diminish or be prejudicial to the public confidence in the administration of justice. Please, I think both sides have been guilty of it. And especially my dear sister, Marietta. At times, yes, you made statement even touching on the demeanor of witnesses. So please, it's a passionate plea from the bench. Let's respect the ethical rules. Yes, Mr. Opon too, you were also guilty of it because you were at the news file, and we think that since you have been announced in this case, it is unacceptable. Yes. Mr. Menuvo, your name appears on this airline. Yes. Yes. So please, yes. Yes, as a member of the General Legal Council. So please, let's take our own rules seriously.
Yes, but my Lord, speaking for myself, I have never...
No. I'm drawing your attention to it. Your name appears here.
Yes, my Lord.
Yes.
So it is encouraged you not to do.
Yes.
Order in court, please. Order.
By court, this petition is hereby adjourned to Tuesday, the 9th of February 2021 at 9:30 a.m. for legal arguments. It's okay.
Mr. Tigata, you don't need a wig. No, you don't need it. You don't need it at all.
All rise.
Reading to read, reading to learn. Mama, I want to learn to read and write, to read to learn. Papa, I want to learn to read and write, to read to learn. I have a dream, and it's to be a better. learning to read, reading to learn, learning to read, reading to learn. Mama, I want to learn to read and write, to read to learn. Papa, I want to learn to read and write, to read to learn. I have a dream, and it's to be a better person. I have a dream, and it's to help my nation. Learning to read, reading to learn, learning to read, reading to learn, learning to read, reading to learn, learning to read, reading to learn. Susu.
Susu.
This is a Rebecca Foundation project to help children read and learn.
Showing every Saturday at 2 p.m. to 2:30 p.m. and repeated on Mondays at 6:30 to 7 p.m. on Netu TV.
Two things happened in court. First was the cross-examination of Rojo Metal. So let me talk about that first. That Rojo Metal was cross-examined by both counsels. And certain things stood out. One, the issue of on double for particular reasons. So, for example, it has two sheets with different numbers on it, and yet the same valid votes. And in court, we saw that apparently there was a third one lurking somewhere with a different timeline. We also saw that, for example, if you read his witness statement, Greater Accra was also an issue. Greater Accra, the numbers on the sheet did not add up. And interestingly, if you read the witness statement, you see that what was published, or the summary that was published on the website or by the EC, was different from what was actually given to the agents in the collation room. The other thing that came up was the fact that this was the National Collation Center where the returning officer, Jean Mensah, was supposed to be in control. We heard from their cross-examination that for a period of 3 hours, the agent of the petitioner was trying to get his problems or the issues that he had seen across to her without any success. We also saw the fact that they state that if you have signed the sheets, even if there are glaring problems on the sheets, nobody is going to do anything about it. This should give us all cause for concern. But even more importantly is the fact that Rojo Metununu reiterated under cross-examination that it was the EC chair who asked him to convey message, information, whatever you describe it, to the petitioner. And if you read the witness statement, you realize that it was about a potential stakeholder meeting to discuss the concerns they had raised. And of course, as soon as they left, the EC and its chair, Jean Mensah, made arrangements to declare the results. Now, all these are issues of concern. Now, you ask us, you probably would ask, how does this relate to the reliefs? If you have several collation seats for one region, which one was used for the declaration? I don't know. If you have sheets with different words in numbers in words and numbers in figures, which are different, which one was used? for the declaration, or for collating, or for adding up the numbers. The only person who can tell us this is the EC chair, who's the returning officer. And that leads me to the second issue that rose today. They claim that they are not going to, or they stated, it's not even a claim, they stated clearly that they are not going to call any witnesses, even though they have submitted witness statements. Now, I don't know whether it's evading, running away, whatever, but they are avoiding or running away or evading the cross-examination of Mr. Chikata. We should remember that this is the EC, which has a constitutional duty to the people. They have an obligation to account to us for our stewardship. And they say they are not going to take the witness stand. Well, tomorrow we'll see how our lordships will rule on this. And the issue was raised whether it's a human rights issue. I don't know. This is the EC chair, a body created by the Constitution, which has an obligation to account to us. They are obliged, they have a duty to respond to our questions. They cannot, EC cannot hide under human rights to say they are not going to respond to us. So I respectfully disagree with her ladyship when she said it is a human rights issue. It is not a human rights issue. They are obliged to respond to us.
Thank you very much for this. I'd like to find out, you have closed your case today. You've closed your case today having called 3 witnesses, Asidun Ketia, Roger Metal Nunu, and Mr. Michael White. Having listened to them give evidence, would you say that your case is still tight? You intended to call some more. You advertised for 5. And when you asked the court for an application to look at documents within the EC, you were shut down. You now have 3. Would you say that you have a stronger case still?
Won't I say that? I couldn't hear.
Your case is still strong?
Yes, I think we still do. Because there is the issue of the declaration, which is why we are in court, where we stated clearly that even on the face of their own documents, nobody got 50 plus of the votes, of the valid votes. And in addition to that, as at now, the EC itself has come up with different figures. They're ever-changing figures. Which one is the valid votes, which is supposed to be used for the declaration? They haven't answered that question.
Yes, Counsel, you have filed a petition making the point that no one got more than 50% of the votes cast. Each time your witnesses have been cross-examined, you've told us that you were satisfied with what has transpired. Should it not be in your interest that you've closed your case and the respondents you are seeking reliefs against are saying that, look, we don't intend to lead any evidence to show the contrary, that people had more than 50% of the votes cast? I mean, should that not be good news for you, actually?
Let me say it's of concern to us, and that is why we are going to oppose the application tomorrow.
Maybe closely linked to that, or following up on that, is a question of the relevance of that particular cross-examination to your case. The lead counsel for the Electoral Commission had made in his submission that indeed they are satisfied with what you have brought to court, and they think that the court can go ahead and make a determination without the benefit of the testimony and cross-examination of the returning officer. How crucial is this cross-examination to your case?
First of all, if we did not have a case, then they should not have filed any answer. Then they should not have submitted any witness statements to the court. each of the parties have submitted witness statements. But my major concern is with the EC. That is accountable to all of us. The EC cannot say that it will not respond to questions raised by a petitioner, by a candidate.
One question that ran through the cross-examination is, with all the three witnesses you presented, is do you have figures that shows that the second respondent did not get the figures, I mean the percentage that he had? That was one of the questions that ran through. I want to find out, you realize that, I mean, no figures have been provided by the witnesses and then the petitioner. Do you think with this, the court will grant your reliefs? Because the question that went through was, do you have figures that show that the second respondent did not get the percentage that he had?
First of all, please go back to our reliefs. Go back to the declaration. Go back to the different figures that have been churned out by the EC. I keep answering this question. I've already answered it. That by the declaration, by the different figures that have been churned out by the EC after the declaration, it is obvious and it is clear that no candidate got 50% or more of the votes. As to whether, what was the question? I mean, with regard to our figures, that's irrelevant to the case. We've come with the EC's declaration itself.
I have a question. How compulsory must Jean Mensah's cross-examination be for your case to succeed? In other words, is the success or otherwise of your case hinged solely on her cross-examination? And if that fails based on what the bench will rule tomorrow, would you then determine that you have a lost case because you are unable to cross-examine them?
Of what you're saying.
If the bench rules tomorrow that she should not be cross-examined, would that throw your case out of the window automatically?
Well, first of all, we'll take it from there. We are going to argue whether or not the EC and the second respondent should take the witness box. Our view is that they have an answer there. They have submitted witness statements, and they ought to be cross-examined on those matters stated there, because that is what they are using to challenge our case.
Yeah, but
so
my question is,
yes,
your argument has been put forth in the courtroom. Now the determination will be made by the bench tomorrow. Is the success or otherwise of your case hinged solely on this cross-examination? That's the question.
You note that when you go to court, your case is not just based on your pleadings and your evidence. There is also an answer, and in this case, there's also a witness statement. And we think that it is important for us as petitioners to be able to cross-examine the EC in particular on the matters that she said.
Madam Winase, and the echo so our courts. Ye mamunyina ehu se sebi we die yano eda seminaso pa se ye de petition at the bar court 30th December yan wie kura na ode answer emuaye at the bar petition no so samuaye no eyensem na ode to answer no so afi ye say fa wenu masem evidence a support wo answer no fa betu court n'anima o say ndie mempe meko na se wo mpe na wo court dia ndie de aba court no say court no enye den emfa mayen na court no nka say or order for runoff. It's as simple as that. Where enya dia ye ni electoral commission ye ba be twentwen ho asem Yen ye dia asama ba ko say two candidates no obia bia ni wa onya 50%. What the answer their back court say enye no kre. Yes, be ya no e den ti asama John Mahama ka no enye no kre o say ne de me pese me nka. Se woni bibia e di hinta den ti na wudwane. Sebe akankasem yes o dwane ekọ ahimfie kanea ene nkyere so ayeden. Aje se ye tutu wenum ayeden asem. Emne du si ebe tutu wenum asem a o se dabi we de misro dabi we de yesre adabraka. Ye maame embra witness boss no. Ejuma o di no Ghana bia 30 million Ghanaians onu kwa na etimi di se ejuma die no. Onu kwa na returning officer ono kwa na constitution edi se ejuma-die na di ayeden edi ahye ne nsa me amika say mintimi ndi se ejuma-die no John Dramani Mahama enya de obetumi ayeden edi se ejuma-die nipa ba akopɛ sada no wa na wo ye declaration wa na wo gina ho simpie so se a ina wo kasa ye be kire ye akonta a wo ye ya wo arrive at that calculation a wo se ne de memma we de yesre no yenko akonodi yenko no gopo yebeye no court damu ha yesre no se ye na ye no osomo ya sa da ye no etwam on yo mra na nyame ya adoma ekina yebeba ni ye the legal argument e dia betai e dia betudwa sebe woni hwe ehinta beka wenum aseme afarijan the first na wonim de ye wanwa Emra na nado danko akufado ede petition ede ba ha wonu de na no oka de oka nyina no se presiding officer ansane polling agent asane bayembo abato no eheden engu ni en declare ono mampeni afarijan wa maha yentutu nanum asem wan hu Philip Addison na no de pink sheet ede kire no na ye ma media den kura no ehun ntia sebe den kura no odi sie Ghana fo ono na etua no ho sebio ono na etua no ho na owia onko parliament enkoji sika enye Ghana ye foto na ede ma no enti sebe ekwan be nsu na ogina ne a ose no de I mean look edwe bi ya ba ejuma o yenum ye nyina esi ehun se dwe ahamanso ewo ne mre eye court da mu ne ewe yenhwe akira de besi afọ de rojo metinunu ebeye ne de sebe ye nyina ye den ye hwe ye omo ye ya so mema wa ye den wa contradict no ni nyina ye den anye ye bebi a wogina no hwa no ye den ogina in fact ebeba mu kra se emra omo lawyer ka se ndc ni bia mehunu na omo an eva mu si ye no ene ye hu se okra omo maniti wan de nyankopo eno no osuro se oba witness boss no mu a sanyoma nyina ba bede di ana sebe ye nyina ye hu se eye Ghana ene ye som enye obi bia medam ase mutie ni ye Abba, hey, Narabi, don't come and do any meeting. No. Come pressure. Yes, that's it. Now did you bring it? Excuse me. So, colleagues, let me know if you are ready, and then we can proceed. You're good? Good afternoon to you all, and thank you for joining us. Today hasn't been as long as I think the last time we were in court. Today, two major things happened in the wells of the Supreme Court. First is the formal announcement by counsel for the petitioner that, my lords, we have closed our case. And you notice that the court, by court, admitted that they have formally closed their case. I'll speak about what that means and what it means for the next step.
prior to that, you saw the petitioner put in the box his third witness, who I believe many people were hoping will help adduce evidence that will advance the petitioner's cause. It is not for nothing that anytime we come before you, we go over the issues that the court is seeking to determine. Because sometimes you may hear they are in court, they are in court, but the issues may get missing. So please permit me, when I repeat the issues, what the court is seeking to answer. The court, on the 20th of January 2021, after listening to the petition and the answers, and reading the memorandum of issues, set down the following issues for the determination of the petition. All of the conversation you hear going back and forth is about these issues. And the petitioner is being required to bring witnesses to adduce evidence to settle these issues. Issue number 2, because the first is an issue of law that the court will determine. Issue number 2, you're expecting that when witnesses mount the box, they will provide evidence to the effect that based on the data contained in the declaration by the first respondent of the second respondent as president-elect, nobody got 50%. You are expecting that when a witness mounts the box, the witness will provide evidence to the effect that the second respondent, if you include or exclude Techiman South, did not cross the constitutionally mandated threshold of 50% plus 1. You would expect that when a witness mounts the box, that witness is adducing evidence essentially that will prove that the declaration of the first respondent on the 9th of December was in violation of Article 63.3. Or at least you expect that what the petitioner has listed as errors in the petition, this witness will provide evidence that shows that these errors and these alleged vote padding affect the outcome of the presidential election 2020. So far, we have seen the petitioner put 3 witnesses in the box, and we are of the view that the court will do a good job in determining whether or not these witnesses have provided any evidence that supports the petition and these issues that the court is seeking to determine. Now, it is upon the completion of this, and note that the petitioner advertised 5 witnesses and ended up calling 3. It is upon the completion of that that the petitioner has now announced to the court that this is all that the case is about. And you heard Mr. Chikata say, my lords, our case is closed. And His Lordship, the Chief Justice, say, by court, the petitioner's case is closed. If we were in a criminal trial, what will happen now is that the court will have to determine whether or not a substantive case has been made, in which case the defendant or the defense may now raise an argument that maybe no case has even been made. So I don't even need to bother raising a defense in the first place. In a civil process, there are similar remedies. What you noticed happened, which is the second matter I'll speak about, is counsel for the first petitioner announced to the court that the evidence, counsel for the first respondent, I beg your pardon, announced to the court that the evidence that the petitioner has provided is enough. And the cross-examination that has taken place is enough. And that the first respondent does not intend to call witnesses to adduce evidence, any further evidence before the court. And counsel on the side of the second respondent has advertised same. Because by now, whatever evidence that the petitioner has put before the court, once the case is closed, it is believed that they have brought all their evidence and they have made such a strong case. And so it should actually be to the disadvantage of the respondents if they say that they don't even intend to call witnesses to adduce evidence. But you notice that the petitioners are not too happy about it. They want literally to compel the respondents to bring in witnesses to, I don't know, adduce some evidence that may help the petitioner in his cause. The court has adjourned, as you heard, to tomorrow morning, and we'll listen to the legal arguments on both sides. We are very, very happy, extremely happy that the petitioner has come to the end of his case and has adduced all the evidence that he has. Evidence which is supposed to prove that nobody got 50%, that whether or not you add Techiman South, the winner will change. that Article 63.3 has been breached. This is all the evidence that they have, which they have made available. And we'll hear what the court says tomorrow as it proceeds to deal with the matter. Yes, sir.
Okay, I think. Thank you very much. You have said 10 times that you intend bringing at least Mr. McMahon to testify. I know you're not responsible for the first petitioner's witness. They have said categorically that they will not present her to testify. But why has the narrative changed? At least we know that Mr. McMahon was going to be in the witness box. Thank you very much.
I want you to go back and play the tapes of our press briefings here. The narrative has not changed. We have always insisted that the onus of proof lies on the petitioner. Sections 14, 17 of the Evidence Act are very clear. He who alleges must prove. You have told your supporters across the country that you won and that they should get on the streets. People died. People got injured. People got involved in infractions with the police and got arrested because you told them you won. When you came to court, you abandoned that and said, nobody won. And the court has invited you to prove. We have always maintained that we are waiting for their witnesses who will adduce evidence to prove that at least their second argument that nobody won is true. And we have always maintained that Chairman McMahon is ready on standby, that when they prove this and it becomes necessary for us to go into the box and prove that what they are saying is not true, because they would have made a preliminary case, we'll do so. You have seen their 3 witnesses. The court has seen them. The whole country has been watching. We've all been waiting with bated breath to see the evidence that nobody won, to see the evidence that when you add or you don't add Techim and South, the results will change substantially to mean who crossed the 50% threshold, to see the evidence that Article 63.3. And on our side, we are not convinced that any such evidence has been put. And that is why we have announced to the court that we don't intend to call any fresh witnesses or any witnesses, because on our side, the view and the belief is that that case has not been made. So the narrative has not changed. The whole country has been waiting. All the NDC supporters, I'm sure, have been glued to their TV, waiting to see their officials prove that nobody got 50%, or that at least the first argument holds true. Now they have announced to the court that they have finished their case, and I'm sure many people are surprised. Now the second part of your question about why Chairman McMahon will not be taking the witness box. A party advertises to the court how many witnesses it chooses to call or its intention that it may call X or Y or Z. And as you heard the bench in exchanges with the lawyers, there are questions about when that election takes place, which I think questions will be addressed yesterday. But isn't it interesting that Mr. Mahama himself, the petitioner, did not mount the witness box? And we are not arguing about why he's not in the witness box. Why has he not taken the stand? Why has he not taken the witness box? Can anybody force him to take the witness box? The petitioner himself. Even to court, he has been here twice, and other representatives come on his behalf. Can anybody force Mr. Mahama to take the witness box? Can anybody force the other 2 witnesses of the NDC that by force they should get into the box? So if you're asking about Chairman McMahon's or the announcement that we will not be putting anybody in the box, as I've mentioned, it is because our lawyers are of the view that that basic threshold has not been met. They have not adduced any. I don't know if you have seen evidence that shows that nobody won the election or that 63. This is what they told the country. This is what they told the court subsequently when they came. And our lawyers are of the view that that hasn't happened. That is why nobody will be bothering to take the stand. And tomorrow they will advance legal arguments to that effect. But if your question is about why he isn't taking the stand, maybe we should ask why Mr. Mahama is not taking the witness box as well, and why they are not bringing the other 2. Yes, sir.
Counsel, if it happens that tomorrow, we don't know, the justices agree on the other side that the witness, the EC chairperson, should stand in the box, are you going to call Mr. McMahon eventually? The calling of Mr. McMahon is very different from the EC's posture. Mr. McMahon is representative or is a witness for the second respondent. We are of the view that the petitioner has not crossed that threshold, and that's why we have announced to the court that we will not be calling Mr. McMahon to bother to even give any evidence, because no substantial case has been made. That is the opinion of our lawyers. Now, should the
EC change its mind, or should the bench decide that the EC should go in and answer? It has nothing to do with our side. We have made a case, the court will make a determination on whether or not we should be forced to put a witness in the box when we are of the view, and the evidence, I think, as has been seen by many, is in question about whether or not they have made a case as they had advertised earlier. Yes, sir.
All right, sir. I believe that this is in the interest of all Ghanaians, and irrespective of the fact that this is between the petitioner and the Electoral Commission and Nana Akufo-Addo, Ghanaians are also expecting an answer from us. And so I'm asking that why don't the second and first respondent allow EC to step into the box so that he will clarify some notions made in some heads of some people?
Yeah, I think that's a very good question. Last time you raised a similar question, I made the point that this is a court of law, not the court of public opinion. This is, with the greatest of respect, this is not the Public Accounts Committee of Parliament that the EC must give us some answers. This is not budget hearing of Parliament that the EC must come and justify its budget. You have come to court with a specific petition, and the onus of proof is on you to show to the court that this is the basic case, and therefore somebody has a question to answer. Where you have not met that threshold, you cannot resort to what I keep telling you are propaganda answers. That when you lose the legal battle, then you resort to propaganda questions and answers. That, you know, it's in the interest of all Ghanaians, and so why the EC? No. And let me also make a distinction. In the 2013 election petition, the Electoral Commission mounted the witness box. Why? Because the petitioner came to court with results of about 11,000 polling stations, pink sheets to back same, and to make an argument that when you deal with the lack of signatures, the multiple serial numbers, etc., which are all infractions, and you strike them out, you have to call a proper declaration of the result that Nana Akufo-Addo is the winner of this election. He came with evidence and made a case. You have been here, and you have heard the bench labor asking the petitioner over and over again, where are the numbers? Where are the numbers? Where are the numbers? And time again, they make the point that it's not even relevant to their petition, and that they are not here looking for new numbers or anything, or a new declaration, but they are here to question the conduct of the EC chair. The two cases are very different. One came to court with pink sheets and evidence, and the petitioner in 2013 mounted the witness box. Dr. Alhaji Mahmoud Baumia, who was one of the petitioners, mounted the witness box to advance his case, made the case, and therefore the EC had to get in the box to respond. You have been here. Have you seen their pink sheets? Have you seen their regional? Have you heard them answer the questions when the bench puts the question that, what are the numbers? So the two cases are different. And it's not, you know, that is in the public interest or is in the public interest. This is a court of law, not a court of public opinion. Yes, sir.
It is true that the petitioner has not been able to give out any figure that show that the respondent did not win the election. But the argument they are making is the consistent change of figures by this first respondent is the reason why they are in court. And you think they have no case?
The court has said that as the last issue to determine whether or not these so-called errors materially change the result of the election. It's one of the issues that the court is going to determine. And that is why at every material moment you hear, for example, the Venerable Akoto Ampao, and today you heard him ask that same question of Ruju, that I want to suggest to you that this your 1,700 or so that you are talking about is not material enough to affect the outcome of the result. You heard that question, and you heard his answer. He was being evasive, but you heard his answer. The point is that the so-called errors, or the phrase that they like to put out, the propaganda phrase they put out, the ever-changing results, like how they put it. Even if you admit that those are substantial errors, the question is, does it change who won the election? If somebody beats you by 500,000 votes, and you come and you say, I saw 1,700, which I describe as vote padding. The court wants to determine whether or not it is substantial enough to change the result. And that is why at every point in time, we keep asking them to provide the court with those numbers that will show substantially that it can change. And you hear them over and over again decline so to do. I think that for the millions of NDC supporters who are watching across the country, they will also be asking questions. Because now there's a clear difference between what the petitioner and his colleagues told them on the night of the election and what they are saying in court, and some of the admissions they are making in court. For example, you heard Mr. Roger Metununu admit that for almost 3 hours, he had left the strong room and was at the reception of the commissioner and admitted that he was having tea, but then, you know, argued that there were no biscuits involved. These things may sound as funny, but the supporters of the NDC down there across the country will be asking themselves that, so while they were out there, having been misled that they had won the election, this is what their seniors were doing at the premises of the Electoral Commission. This is what they told the public. And now when you come here, you have to make some admissions. So the jury would, the bench will make a determination at the end of the day. Colleagues, are there any other questions? Let me yield the podium to my colleagues to translate it.
Abujanfo ye bedamo ase ene eye da toso eye dumienu a ye de aba eye Supreme Court hay na ene ye nya yenim na no fiada ena NDC eto nsa anase petitioner opani mahama eto nsa edefre na dance ni a otoso miensa ene nye twato na ene ye toto na no na toto na no yenya yehu ensem ni bi epieye na ne hu hia ye pa no eye ensem a court no ode asi nani so se obepa hu muaye ne hu hia nyina ne se Nanado Danko Akufuado, His Excellency onya eye ohanumu nchichemu aduonum ene akire ana eno yade esi court ni super ipa ye eti nsemo a wo beka bia no o se unya so muaye na unya ni nyina so ene omufre Rojo Metonunu ye nyina ye tin nsem ni bi o kan ye ene ye busa no o se ono na dwuma obedi ye na bi wo honom a ayemfomso odne sa hyekra taase ukobusa na o se ayemfomso no ye ebi wo hon so a o se o ye sansa na ompese obeye akwansidie ede ama Electoral Commission we nyina no aye nsem a otimi se na ensisi so afa kra de o se EC epamo no efri dem honom eno ye ene ade ba kwa beto dwa na yehu se no so no ensisi so ebie ade ba kwa asa kan ye krampa o admit ye Electoral Commission ema accreditation obia enan o eti se bibi kramposi na empanifo mienu se mo kɔ ba bia eye mienu na aka akire no awose nkomutimi ginam we ye hu ne saa obusa no so a onya anu ye mfama ne ebusa ne se donhwere eye miensa a wukodi wo ye oba pani Jane Mensa office a na ɔte hɔ no mo nipa ye de wakɔ se kona kodi dwumadi kɛse sei se wo hwɛ ɔno a ne krata de abre court na wo hwɛ ɛpɔ a ɛtɔ so miensa ne o kyerɛ nyina ne se ye ne kɔ hɔ se ɔnkɔ no hwɛ ma ɛba no na ne gi ho a no ne sa hyase ɛwɔ no akrata mu enipa ye de wakɔ akɔtena EC akache se kɔ na kɔ di dwuma kɛse sei ɛfama wo party ukɔ ya wagya dwumadi na si hɔ ɛna uti EC ɔbapa office don hwere miensa ɛna wunum tea na yesa busa wa wo se mum na biscuit nka ho wei ayen nsamo a opani Rojo Metonunu akɔka yo na anu bɛka ya opani ba ko ba Dr. Kwesa White ɔso ɔno so agya ne charger wo fie ntine phone bedum ye wo hwɛ enniema a ɔmo ka ne nyina na yɛsɛ enya dwuma pa bi ɛna ɔmo ba ya ɔmo ba ebedi ɛwɔ hɔnom itiana yehu ne nsɛm no ano totoɔ no sɛnea esi kɔɔyɛ na ebra ye wie ne nyina no etoto na no nyina wie ye EC ewie ne de opani akotampa wie ne de ɛna EC ɛde tu dwa sɛ wo hwɛ emranim Now we share a year order 36, SCI 47, no, 36, rule 4. Now can hobana. Send your metie a year opinion sedun ketia, ometie na no asem. Na ometie a year Dr. Kwesa White no asem. Na omase tie a year opinion Robert Joseph Metununu. Ometie na no asem ne no. Dabi ehun hia kra se omasem no ko mbedi adanse bia biom. Sansan nsem ni nyina so no omantimi amfa nyina so bia no ama. Ena opinion chatu se dabi se ne tie bia no o se frɛ no na yede ne ba. Ɛhɔ ena court ede aba bedru. Na wotie nsem no bia ye nua no mandisi fo ka. Omo se die ben na obapa EC o dwane afiri se obegyina adaka mu. Abusuafo musuma busam ho se edie be pa na former president Mahama wusi awiawo. Na wusi wadi nkunim. Afa be wie court de wusi da obi anim nkunim yensan kɔtɔ aba no foforo. Abusuafo yensu emusa former president Mahama se wa wode wasɛm aba court wo bɔkɔ adu. Na wamfa nyina so bi ama no. Ade na wode wa metra box no me antoto wa no. Abusua aha ye de mra na ye adwuma. Nwanwa obeka ya 2013 no so mo de ka ho asɛm se 2013 eye Dr. Farijan etna adakam no kra Dr. Farijan tna adakam san se enyina so aye de bae no na emu pi ye ba ansa kra ne ba ne de 6,000 pink sheet na ba ye di asɛm ne koso no ne sade another 12,000 epubusia ene epim edu mienu ko na chim etebusuafo yen ye di nyina so de ba enti na ehu be hia se Dr. Farijan obetena adakam na ye doso no ende mumbu sam ho se a judges from penifo ekura busa NDC for se na munyina so won here my lord I have not brought that figure to court manfa sa nkuntabo na ma court e mando do sai na mumu candidate ni nya I have not brought that figure to court yanfa sa ma no ama court dem ha sei na e ka me akwa se enyina so bia ni nsem mo e kanim enti wei ene babia ene ye bedru ye na nyame ya adom a ochina court ebesai atenase na ensem a ye ka no ebiem yenso eye opania kotampaw wadi kan da na di se enya de a ono so no in witness ko be frɛ no sanse eye omo de asem beto court no omo nhyedan fa asem kese bia no embam beto dwa enti mesrem ebiem omo kra de omo sa de hye kra tamu kra se omo be fra dansefo enum ebe wi akye no enei omo krosi omo case kese omo asem ankasa omo de bae omo kwadu omo de bae no omo nsem nya no omo toma no mutu awie omo wie ya dansefo miensa pe no omo frɛ mo obi ahye omo kete se omo ko frɛ tu na aka namra mienu na aka akye no omo ko famra na dabi obi anhye omo enti ade ne de untimi nhye obi se wa o case nya no osikyinkyina wo pese obi nso ede na asem obegyina adaka mu na odoso no enti abusuafo saa na ye kɔ wie na mesrɛ mo se na de bia mo me ho adagye na mo me hu behia ye mpanifo mo ha sei no awo se timi do madi the most general secretary of the ruling New Patriotic Party ono amu wa ha sei chairman Makmenu so kan ho lawyer Joyce Boatin Opoku Boatin enso kan ho ha sei president Ankasa lawyer call a suman enso kan ho ana yenua part of the research team ono so wa ha sei bi lawyer Nana Adjoa Adobia Asante Mrs. enso wa ha ana ya yehu minister designate information Kwadwo Ponkruma ana yenua ba deputy director at the communication presidency enso wa ha sei ana ebiem ya yenua ba kon lawyer Patriot Faisal ono so ejiremu dende maye ya lawyer for lawyer Kotampao lawyer Frank Davis lawyer Dapa Ado lawyer Yao Opon lawyer Kweku Esrifi lawyer Sheila Minkapremo lawyer Victoria Bath lawyer Ochre Ejekum lawyer Ernest Owusu Dapa ena K Amwa lawyer omunyina eboye chidom nyame nhramo nyame yadom a yesa behia ochena na yakoso yadi ejuma mede nyame jamo.
Okay. Welcome to the Presidential Diary, brought to you by the Communications Directorate at the Presidency.